Hey everyone, can all five of my jurors just come on the screen so I can see you and confirm that I can hear you and that you can see me, etc.?
How you doing, Phil?
Hey, how you guys doing?
How you doing, Phil?
Good to see you guys again.
Good seeing you.
Hello.
Hi. I think we're missing two more jurors that I can say. Okay.
Good
Juror
afternoon, everyone.
continue. And just one more of our jurors, our last juror. There we go. Can all five of you hear me? Just give me a thumbs up if you can. Excellent. All right, we're going to get started in just a few minutes. Thanks, everyone.
All right, thank
Thanks,
you.
Phil.
Can a representative from both teams just let me know that everyone who needs to be in the Zoom room is here?
Everyone is here on behalf of the prosecution.
Okay,
Same for the defense.
excellent. Okay, we're going to get started in just 2 minutes. I assume that everyone, including our jurors and witnesses, are ready to go. And Judge Goss, I assume you're ready to go as well. Born ready. Excellent. All right, we're going to get started in 2 minutes on the hour. Thanks, everyone.
Team 23, Robert's partner.
Sorry, 43, that's right up there.
St. Elizabeth Hospital.
Welcome, everyone, to the championship round of Battle of the Experts 2020. For those of you joining us online, the millions of viewers watching at home on YouTube, thanks for being here. You have to wonder what the NFL was thinking putting their games up against our amazing championship round. This is a clash of two incredible teams, maybe two of the best teams in Battle of the Experts history. Representing the prosecution, we have Team 112, and representing the defense, we have Team 108. These teams have competed in 4 rounds each over the past 3 days, and they've been dominant. They've won 7 of their 8 trials. They have won 19 out of 24 possible ballots in those trials. So this is going to be one heck of a final round. Our presiding judge is the Honorable Jason Goss. And with that, I'll turn it over to him. Judge Goss, your courtroom.
All right. Thank you, Phil. I guess I will ask, first of all, yes, if I could just see the prosecution and defense advocates on the screen. That's good. For everybody else, just remember that one of the rules is that if you are not speaking or you don't have a role, you'll put yourself on mute and you'll put your video on mute. I'm sure y'all are used to that by now. I guess for congratulations to both sides. We're in the finals. I know it's going to be a great round and I'm looking forward to it. So first and foremost, I need the appearances from both the state and the defense.
Good afternoon, Your Honor. Daniel Craig on behalf of Team 112, along with my co-counsel.
Taylor Maurer, Your Honor.
We represent the prosecution, and once defense counsel has had a chance to introduce themselves, we have 3 housekeeping matters and 2 stipulations agreed to by the defense.
Okay. Defense.
Good afternoon, Your Honor. My name is Avery Hitchcock, appearing on behalf of Team 108, aka the defense of Timothy Ray. Today I'm joined by my co-counsel, Mr. Blake Barrich.
Hello, Your Honor. My name is Blake Barrich, appearing on behalf of the defense.
All right, thank you for that. So, and we'll start with housekeeping. I understand prosecution has some, and defense, I'll give you an opportunity for that as well. Let's do housekeeping first, and then any kind of substantive motions after that for each side.
Yes, Your Honor. First, the prosecution requests the sequestration of all fact witnesses. We understand that expert witnesses are not typically sequestered, but just both police officers being called in this case, we request to be sequestered.
Okay, and that constructively, I guess?
Yes, Your Honor.
Okay, and is there any objection from the defense on that?
No objection, Your Honor.
Okay, that will be done. So the 2 police officers will be sequestered. Yes.
Also, Your Honor, we ask that all sidebar be constructive so that the jurors can hear the arguments being made. We understand that sidebar should still be requested, but we just ask that it be done constructively.
Sure. As long as you guys let me know that, and lady, let me know that we are that going outside the presence of the jury to discuss an issue. Yeah, everything else will be constructive. I do want these jurors to be able to hear all the arguments that the advocates make.
Finally, Your Honor, on page 5 of the electronic binder, stipulation 1 says that all exhibits on the joint exhibit list are authentic. We just ask that we don't take the time to authenticate exhibits based on that stipulation.
All right. I don't have an issue with that. Defense, do you have an issue with that?
No, Your Honor.
Okay. Yeah, that's fine. You won't have to ask the authentication questions. However, if you do have any other predicates to get over hearsay and everything else, I'll expect you guys to argue that.
Understood.
So, okay. Anything? What's next?
We have 2 stipulations. That's all for our housekeeping matters.
Okay. Is there any housekeeping from the defense?
Just one thing actually that popped into my mind. All exhibits in this case are pre-marked as joint exhibits, and we just ask that they retain these markings regardless of the order in which they are received for the convenience of court and counsel.
Okay. Is there any issue with that for the prosecution?
No issue.
That'll be granted.
Other than that, we also have a stipulation, but obviously the prosecution goes first.
Okay, sure. So we'll hear from Mr. Craig.
By way of background, Your Honor, this is a case about a man who strangled his 6-year-old son to death and then tried to cover it up. The defendant is now claiming he has schizophrenia and that he was insane at the time of the murder. To help the jury decide that question, both sides have retained experts in this case. With that in mind, defense counsel has agreed that neither expert will provide any testimony that would violate Federal Rule of Evidence 704B about the mens rea required for a crime. Now, we understand that under the governing case law in this jurisdiction, Pasquarello v. West Carolina, that the experts may testify as to whether the defendant had a specific disease and the qualities of those specific disease generally. However, we have agreed that neither expert will testify if the defendant knew right from wrong or could appreciate the nature of his actions at the time of the killing.
Okay, and Mr. Hitchcock, is that the stipulation as you understand it?
Yes, Your Honor. We agree that we won't go into the defendant's specific state of mind into whether he knew right from wrong. However, just with the caveat that we would like to note for Your Honor, Pasquarello, controlling case law in this jurisdiction, does state that we are allowed to provide evidence that a defendant was suffering from a disease at the time an alleged criminal act occurred, and discuss the potential symptoms of that disease without violating Rule 704. So with that in mind, we have no objection to the stipulation.
Sure, and that's how I understand. I think you both have stated Pasquarello admirably, and I think that that's correct, and that's my understanding of Pasquarello. Obviously, I will allow the defense and the state to talk about the specifics of schizophrenia or any other mental illness or disease, but it sounds like your stipulation, you guys, if y'all follow it, that's great. If y'all feel that somebody's not following it, just call my attention to it and we'll talk about it then.
Understood, Your Honor. The final stipulation for the state is regarding testimony from Officer Peyton Wentz, who's a defense witness. Now, both sides of this case will be calling police officers as witnesses. The government understands that these police officers will be able to make general lay opinions about the defendant's behavior and words when they interacted with him. However, if I could draw Your Honor's attention to page 50 of your electronic binder, it's part of Exhibit 5. On line 12 of that interview with Officer Wentz after the killing occurred, Officer Wentz opined specifically on whether the defendant was suffering from delusions. Given that both sides have retained experts in this case, And further, that one of the specific symptoms that will be debated by both experts will be whether the defendant suffered from delusions. We have stipulated with defense that Officer Wentz will not opine on whether he thought the defendant was suffering from delusions or not.
Okay, Mr. Hitchcock, is that your understanding?
Yes, it is, Your Honor. We agree with the state that delusions are a medical term in this case used to diagnose schizophrenia. And since we're not offering Officer Wentz as an expert, he can't opine as to that. However, he will be giving his lay opinions as an officer at the scene and recounting those types of things that he could rationally base his perceptions on.
Okay. With that understanding, I understand what's going on. And like I said, and that'll apply to what I said before, will apply now. If anybody's going outside the stipulation or violating it, just call my attention to it and we'll talk about it. Anything else from the prosecution?
No, Your Honor, the prosecution is ready to proceed.
Okay, how about the defense?
Your Honor, we just have one additional stipulation. As the prosecution mentioned, we met and conferred before the start of today's trial, and we discussed our desire to admit Exhibit 15. This is a pretrial deposition transcript of Dr. Samantha Di Giuseppe, a former medical provider of Mr. Reyes. Both sides agree that it is admissible under Rule 804B1 former testimony, and they stipulate to its admissibility, so we move for its admission at this time because it will be referenced throughout today's case, including opening statements.
Okay, and you'd like that to be, I guess, admitted as 15, Exhibit 15?
Yes, Your Honor.
Okay, is that your understanding, Mr. Craig?
It's my understanding there's no objection to the admissibility of that transcript.
All right, it will be admitted and you can use it in trial for any purpose.
And with that, the defense is also ready to proceed to openings.
Okay, wonderful. I'll remind everybody who's here in the room with me that if you could please switch your view to speaker view, and that will allow you to see the opening statements and only the openers and only the person who's talking. And with that, I will invite the prosecution to make their opening statement.
Yes, Your Honor. May I proceed?
You may.
What I'm about to tell you is not going to be easy to hear. On an October morning, almost 2 years ago to this day, 6-year-old Nathan Ray made a mistake that would cost him his life. He spilled his juice, ruining his father's laptop. This defendant became angry. He chose to punish his son. And that punishment escalated until Nathan began to cry because he could not keep up. This defendant made another choice. He left the room, picked up his belt, returned to the room, and he put that belt around Nathan's neck. He chose to choke the child he was supposed to protect, tightening until Nathan screamed out, tightening until Nathan stopped moving and he stopped breathing. And then he shoved Nathan's body in a trash bag and he dumped it in a park. This is a case about conscious choices and their fatal consequences. As the prosecution, it's our burden to prove the defendant killed his son with malice. It's a burden we will meet because we will show the defendant knew he was strangling his son and he chose to keep going. The basic facts of this case will not be in dispute today. The defendant arrested. He confessed. He told police where the body was. The autopsy report showed marks around Nathan's neck consistent with being strangled, and there was evidence in his car and on his cell phone that he tried to cover it up. Defendant is now claiming he is schizophrenic and that he was insane at the time of the murder. That's something the law says he has to prove, step by step. First, that he has schizophrenia. Second, that schizophrenia was active at the time of the killing. And third, that schizophrenia prevented him from knowing right from wrong or understanding what he was doing. It's a burden the defense won't be able to meet today. We retained an expert in this case, Dr. Mac LaGreca, to take an independent look at the evidence. The defendant's life history, his medical history, his confession, and his behaviors. Dr. LaGreca has treated patients with serious mental illnesses like schizophrenia, and now teaches future psychiatrists how to treat those same patients. Dr. LaGreca will tell you that up until the murder, there was never a diagnosis of schizophrenia in this man's 34 years of life. That the symptoms he was suffering from were symptoms of anxiety. Anxiety caused by problems that happen in many people's lives and marriages. Dr. LaGreca applied the standards used by psychiatrists every day and determined this defendant does not have schizophrenia. Now, you're also going to hear about a separate diagnosis. It's called malingering. And that just means faking symptoms to concoct a legal defense. And you'll learn that when criminal charges are likely, the likelihood of malingering goes up. Members of the jury, listen very closely today as to when the defendant said certain things. Because you'll learn it was only after the defendant was stopped by police that he claimed the CIA was spying on him, claimed he saw things that weren't there. Story kept changing to police and to his own expert. Dr. LaGreca applied universally accepted psychiatric principles and determined this defendant does not have schizophrenia, but that he was malingering. The science supports this, but so do the defendant's own actions and words. You'll be presented today with evidence that shows the defendant knew exactly what he was doing. Detective Blake Booth, the lead investigator in this case, will tell you how the defendant admitted he put his son in a trash bag and buried him in a park. And how, after the murder, the defendant searched the internet. He went to his phone and he looked up things like how to dispose of a body, will bleach destroy a body, and which countries don't extradite for murder charges. Detective Booth will also tell you what this defendant said about killing his son. Quote, he needed to understand. Quote, I needed to punish him more. Quote, I pulled the belt until he stopped screaming and until he stopped moving. A child is dead. The killer has confessed. The facts are clear. At the end of this trial, my co-counsel, Ms. Maurer, will ask you for the only verdict demanded by the law and supported by the facts. A verdict of guilty for the man who strangled his son to death. Thank you.
Thank you, Mr. Craig. From the defense, who will be the opening advocate?
I will, Your Honor.
All right. Thank you, sir. You are free to begin whenever you are ready.
They missed the signs. Timothy Ray is sitting in a doctor's office. He's been there before. The same curtain in the corner, the same clock on the wall, the time frozen in place. He keeps coming back because he knows something is wrong. Something has always been wrong with him. He tells the doctor, I've never been okay. But instead of getting the help he needs then, Mr. Ray is allowed to leave. He never gets any medication. He never gets any help. He leaves that doctor's office like every time before, untreated. Members of the jury, what happened on October 17th, 2018 was terrible. A parent's worst nightmare. And to think that a parent could do this, it's unimaginable. No normal person would. But today, you're going to hear evidence that'll show Timothy Ray wasn't normal. He was sick. Very, very sick. He suffered from schizophrenia. But the doctors, his family, his friends, they missed the signs. Because of this, we're bringing what's known as an affirmative defense. Now, what does that mean? Put simply, it means that when he killed his son, Mr. Ray didn't realize what he was doing was wrong. Today, we'll prove this by showing you two simple facts. Number one, Mr. Ray was suffering from schizophrenia, a terrible mental illness which makes people hear voices, not their own, and have delusions that just aren't true. Number two, we'll prove that this schizophrenia took control and caused Mr. Ray to harm his son. First, the evidence will show that Mr. Ray was suffering from schizophrenia years before any of this happened. But that Mr. Ray was never diagnosed. You're going to hear from Dr. Shane Riley, a board-certified expert in forensic psychiatry. She'll testify that she reviewed Mr. Ray's history, did an in-person evaluation, and did make a diagnosis. And Mr. Ray had a family history of severe mental illness. He suffered from childhood trauma. Mr. Ray saw hallucinations. He heard voices in the years before his son's death. Mr. Ray had delusions about his wife's affair. And perhaps most importantly, the evidence will show that the people around Mr. Ray saw him acting in stranger and stranger ways as the years went on. You'll learn that his wife saw him go through constant mood swings and that he got more and more isolated. Now, you just heard a story about malingering, but Dr. Riley will explain her thorough evaluation and this third-party corroboration led her to conclude Mr. Ray was suffering from schizophrenia years before October 2018. That it got worse and worse, but everyone missed the signs. Second, we'll prove that at the time of his son's death, Mr. Ray was experiencing a schizophrenic break. He had delusions about his son and wife conspiring against him. He heard voices telling him over and over he had to kill his son. The evidence will show Mr. Ray was still sick when the police found him. You'll hear that a few days after his son's death, Mr. Ray was stopped by Officer Wentz at what was supposed to be a routine checkpoint. You'll hear it was anything but routine. You'll hear that Mr. Ray started screaming these accusations of being CIA in one moment, and then in the next was silent, the blank stare. You'll learn this was schizophrenic behavior. But the evidence will show this behavior was ignored by the prosecution witnesses. You'll learn that after Detective Booth interrogated Mr. Ray, the detective said, "You're a piece of shit. You'd be better off dead." And then allowed the only footage of this interrogation to be wiped clean. You'll learn that the prosecution's expert apparently didn't need to see this footage, didn't need to interview Mr. Ray or anyone else. The evidence will show the prosecution had their minds made up. They missed the signs, they even ignored them. But you don't have to. Now, to be clear, Mr. Ray will regret October 17th, 2018 for the rest of his life. He was a father, and he lost a son forever. But the prosecution will try to say he knew exactly what he was doing. He knew it was wrong. The evidence will show that Mr. Ray isn't evil. He's sick. At the end of today's trial, my co-counsel, Avery Hitchcock, will ask you to find Mr. Ray not guilty. Thank you.
Thank you, Mr. Barrett. I would like to remind everybody to, I guess, change your view to gallery view. All right. And I'll ask the prosecution to call their first witness.
Yes, Your Honor. The prosecution calls Detective Blake Booth.
All right, Detective Booth, you have been previously sworn. You're still under that same oath. Mr. Craig, you may continue when you're ready.
Detective Booth, where do you work?
I work with Skelton Police Department.
Is part of your job to investigate homicides?
Yes, sir. I've investigated 11 homicides before, and this case makes 12.
How did you get involved in the investigation of the death of Nathan Ray?
Nathan's mother reported him missing on October 18th, 2018.
How old is Nathan?
Just 6 years old.
Did you ever find Nathan?
Yes, sir. We found his body in Brandywine State Park.
Who told you where the body was?
His father, Timothy Ray.
Did he tell you how Nathan died?
Yes, sir. Mr. Ray confessed that he killed his son.
Detective, I want to turn your attention to Exhibit 19. It's on page 96 of your electronic binder. Let me know when you're there.
Yes, sir, I'm there.
What are you looking at?
This is a photograph of the area where we found Nathan's body.
Your Honor, I move for the admission of Exhibit 19.
Objection, Your Honor. 403. May I be heard?
You may.
Your Honor, this is a photograph of Nathan Ray's body in the body bag as it was discovered in the park. Now, we aren't disputing today that Timothy Ray was the one who killed Nathan Ray, and the evidence that's already been elicited both through opening statement and this witness has established the probative value that comes with this photograph, that he was buried in a park and that's where his body was found. Admitting this photograph now is only being served to inflame the passions of the jury, as there's no additional probative value. This is exactly the type of evidence that 403 is meant to exclude.
Okay, thank you, Mr. Hitchcock. Do you have a response, Mr. Craig?
Yes, Your Honor. The probative value of this photograph is the question the jury has to decide today is whether the defendant knew what he was doing. This photograph shows that there is dirt on top of the trash bag containing the body, which goes directly to show that he knew what he was doing and he was trying to cover it up. That's a question for the jury to decide.
And let me ask you, because I have seen the photograph, but just to make sure there's no actual photograph, it doesn't depict the actual body of the child or a dead child or a buried child?
No, Your Honor. It's just the trash bag in the ground and then dirt on top of it.
Okay. So, Mr. Hitchcock, I appreciate your objection. I do believe that this one photograph will be probative. I do not believe, using the balancing test, that it's substantially more prejudicial than it is probative. So I will overrule the objection. However, if they try to enter more photographs or photographs of the same, I will entertain a cumulative objection. Thank you,
Yes,
Mr.
Your
Hitchcock.
Honor.
And the exhibit is admitted. What number was that? I'm sorry, Mr. Gregg.
19, Your Honor.
Okay, 19 is admitted, and you can publish and use however you want.
Thank you. Detective, is this where you found Nathan's body?
Yes, sir. This is where we found the body. Nathan is inside the black trash bag. It's buried in a shallow grave. As you can see, the top of the trash bag wasn't completely covered.
Thank you, Ms. Gubernick. You can take that down. Detective, you told us Nathan was reported missing on October 18th. When did you first encounter this defendant?
On Friday, October 19th, 2018, I had received a call around 9 p.m. from dispatch that Officer Wentz had stopped the defendant at a sobriety checkpoint. When I arrived on scene, the defendant was in handcuffs sitting on the side of the road.
Did you speak with the defendant?
Yes, sir. After talking with Officer Wentz, I went over to the defendant and told him that we needed to take him to the station and ask him some questions about his son. I asked him if he understood.
How did he respond?
He said, "I understand. I'll tell you everything." So we took him to the police station to interview him.
When you got to the police station, was the defendant read his Miranda rights?
He was. I had him sign all the appropriate paperwork to make sure he understood what was happening.
Detective, now I want to turn your attention to Exhibit 4 on page 45 of your electronic binder.
Yes, sir, I'm there.
What are you looking at?
This is the Miranda warning and waiver that we had the defendant sign.
Your Honor, I move for the admission of Exhibit 4.
The objection, Mr. Hitchcock?
No objection, Your Honor.
Okay, Exhibit 4 will be admitted. You may publish whenever you need to.
Now, Detective, as you can see, there's a middle section here labeled Your Rights, and there's a section at the bottom labeled Waiver of Rights. Now, I want to focus on this first section first. Now, the boxes under Your Rights, who initialed their initials after each of those boxes?
This defendant, sir.
And under Waiver of Rights, who signed their name under signature?
Also this defendant.
What about that little bit at the bottom about highest grade in school?
Also this defendant, sir.
Thank you, Ms. Gubernick. You can take that down. How did the defendant behave when you interviewed him?
He was visibly upset. He was crying and shaking during parts, but he was explaining how he killed his son. Overall, he was speaking coherently, making eye contact for the most part, and seemed to understand what was happening.
Objection, speculation.
All right, Mr. Craig, you got a response to that?
Your Honor, the witness did not testify that the defendant understood. He only testified that he seemed to understand. He's not speculating. He's just basing it's just based off his rational perception of how the defendant was behaving.
All right, Mr. Hitchcock, do you have a response to that?
Your Honor, being asked whether or not somebody else understands is inherently speculative, regardless of whether it's couched in the word seemed. No rationally based person could observe whether or not somebody has a full and fair understanding of what's going on. Therefore, this is speculation, regardless of using the phrase seemed.
And yeah, I think the way it was worded, I understand, but Mr. Craig, I also take your point. I guess the question is how did the defendant seem to you, Detective Booth? And it seemed like to me he could understand, meaning I guess he wasn't questioning me or acting that way. Is that what you were intending to elicit?
Yes, Your Honor, just that he was just basing it off of his interactions with him, not that he was making a specific conclusion about his mental state.
Okay. So, Mr. Hitchcock, do you have any response to the fact that what they're eliciting is that Detective Booth, in Detective Booth's mind, he didn't get any clue, or it seemed to him that the defendant understood what was going on? Is that acceptable, or do you have an objection to that?
Your Honor, as long as it's specifically limited to what the detective himself was perceiving and not used to imply for later on an argument that the defendant did understand everything that was going on, we have no objections. We just want to make sure that that distinction is clear for the jury, that the detective cannot testify to the defendant's actual understanding.
I understand, and I appreciate you delineating that. And I will say that if an argument like that is made and you feel like that's unfair, you object to me, and then I'll correct that. Mr. Craig, I think that's fine if we can just clarify with the detective that it was something that it was in his impression, and the objection will be overruled.
Detective, based solely on your perceptions of how the defendant was reacting, what did you think about his behavior?
He seemed to understand. Like I said, he was speaking coherently and making eye contact with me for the most part.
Now, Detective, you know that the defendant is now claiming he was insane at the time of the killing. Now, did he ever ask you any questions about the CIA?
Yes, sir. He asked me a couple times if I was with the CIA. I told him essentially to drop the act.
Well, after you told him that, did he answer your questions about the murder?
Yes, sir.
Detective, I want to turn your attention now to Exhibit 3 on page 40 of your electronic binder.
Yes, sir, I'm there.
What are you looking at?
This is the transcript of my interview with the defendant.
Your Honor, I move for the admission of Exhibit 3.
Is there any objection?
No objection, Your Honor.
All right, Exhibit 3 is admitted, and you may publish when you need to.
Thank you. Detective, what did the defendant tell you happened to Nathan?
The defendant stated that on the morning of October 17th, he and his son were eating breakfast together when his son spilled juice on his work laptop. The defendant said he had to punish his son, so he started yelling at him. Then the defendant made his son do jumping jacks, high knees, and run in place as further punishment. But the defendant told me this wasn't enough and that his son wouldn't stop screaming and crying, so he grabbed a belt to hit Nathan on his bottom.
Now, Detective, I'm going to be showing you some specific portions of the transcript. First, I want to turn your attention to page 43, line 10. Now, did the defendant tell you why he went to go get the belt?
Yes, sir. He said he needed to punish him more.
Now, did the defendant tell you how Nathan reacted to being punished?
He said Nathan kept screaming that he wanted his mom and that he hated his dad.
I want to show you another specific portion of the transcript. If you go to page 44, line 13. Now, you asked the defendant whether he pulled the belt tight around Nathan's neck. What was his exact response?
The exact response was he needed to understand I pulled the belt until he stopped screaming, until he stopped moving.
Thank you, Ms. Kubernick. You can take that down. How did the defendant say he was feeling about having killed his son?
The defendant said he was ashamed and sorry for what he had done.
And what did the defendant say he did with Nathan's body?
He said he put his son's body in a garbage bag, put the body in his car, and drove around for a few days before burying it in Brandywine Park off of 22.
Was this interview recorded in some way?
Yes, sir. All of our interview rooms have cameras that record all of the video and audio. I also requested a transcript of the interview.
Now, that transcript, was that word-for-word document we were just looking at?
Yes.
What about the video?
No, sir, that's not available. In our police department, the audio and video recordings get automatically deleted after 30 days unless a request is made to preserve a copy.
Well, Detective, were steps taken that very night into the next day to confirm what the defendant told you?
Yes, we conducted the search of Brandywine State Park that I had already spoke about, where we found Nathan's body. We also got a warrant to search the defendant's car and a warrant to search the defendant's house. We also ordered an autopsy to be performed on Nathan's body.
Detective, now I want to turn your attention to Exhibit 6 on page 53.
Yes, sir, I'm there.
What are you looking at?
This is the autopsy for Nathan.
Your Honor, I move for the admission of Exhibit 6, which is admissible by stipulation from both parties.
All right, any objection, Mr. Hitchcock?
No objection pursuant to the stipulation, Your Honor.
Understood. It will be admitted. You can publish for all purposes.
Detective, according to the autopsy, what was observed on Nathan's neck?
Dr. Rock had found contusions and abrasions covering the front and sides of Nathan's neck, consistent with having been strangled with a belt.
Now, you said, no, what was found at the defendant's home?
We had found a spilled glass of juice on the kitchen table and the defendant's laptop that was sticky with juice residue. We also found a belt on the floor of Nathan's bedroom.
Just to be clear, Detective, is that house right here in Skelton County?
Yes, sir.
Detective, now I want to turn your attention to Exhibit 27. It's on page 104 of your electronic binder.
Yes, sir, I'm there.
What are you looking at?
This is a photograph we took where we found the belt in Nathan's bedroom.
Your Honor, I move for the admission of Exhibit 27.
Is there any objection?
No objection, Your Honor.
All right, Exhibit 27 will be admitted and you can publish when you would like.
Detective, please tell the jury what they're looking at.
This is a photograph we took of where we had found the belt. It was in Nathan's bedroom at the defendant's house.
Thank you, Ms. Kubernick. You can take that down. Did you find any of the defendant's personal belongings?
Yes, sir. We also found his cell phone.
Was the phone searched?
It was. We performed a search of the defendant's internet history.
Detective, I want to turn your attention now to Exhibit 10. It's on page 57 of your electronic binder.
Yes, sir. I'm there.
What are you looking at?
These are screenshots from the defendant's cell phone. On the left is the internet search history that I just spoke about, and on the right is the settings portion of the defendant's cell phone.
Your Honor, I move for the admission of Exhibit 10.
Is there any objection to 10, Mr. Hitchcock?
Yes, Your Honor. 403. May I be heard?
You may, outside the presence of the jury, constructively.
Yes, Your Honor. These Google searches, the prosecution is using to try and show that Mr. Ray had consciousness of guilt and an awareness of his actions on October 17th, 2018. However, these searches weren't made later that day on October 17th, 2018. They weren't made before he killed his son. These searches were made on October 18th, 2018. Since the time in question is whether or not he had the knowledge that what he was doing was wrong at the time that he killed his son, admitting these searches and using them to show that he had a knowledge and awareness of his actions at that time would unfairly prejudice the jury and mislead them because it doesn't go towards his specific state of mind at that particular point in time, which is the only relevant time frame in this case.
Okay, can I have a response, Mr. Craig?
Well, first, Your Honor, that goes to weight, not admissibility. And second, it's my understanding that the defense is going to be calling a fact witness today, Officer Peyton Wentz, that only observed the defendant's behavior after the killing occurred. Now, events that occurred after the killing go along this larger timeline that goes to the more narrow fact of whether the defendant had schizophrenia and whether it was active at the time of the murder. In a case where mental state is the key question, there are going to be events specifically after, specifically before the crime occurred that will go to that mental state. And his internet searches the day after he killed his son, specifically about disposing of a body, go directly to that mental state.
Okay. Mr. Hitchcock, I'll give you a response to that.
Your Honor, we will be offering evidence to show that Mr. Ray was suffering from schizophrenia, and some of that evidence is observations from after the crime occurred, but that's relevant for a different reason because it goes towards whether or not he had schizophrenia, period. That question that's part of our burden isn't specifically tied to one particular point in time, unlike this, where the defendant's specific mental state at the time of the crime in question is. Therefore, using this type of evidence to go backwards and try and establish his particular knowing of right or wrong at that time is inappropriate and inadmissible under Rule 403. Additionally, 403 is essentially a weight versus admissibility type of argument where the weight of this evidence is so low that it should be inadmissible. Therefore, the fact that it goes for weight, not admissibility, is irrelevant to a 403 argument.
I understand your argument. Mr. Craig, I would like you to respond to one of the things Mr. Hitchcock pointed out, or that he is arguing, is that the only relevant purpose for this evidence is to show the mental state at the time the crime occurred, or would be, I guess, or to show the mental state his mental state afterwards, which isn't relevant because you have to prove, I guess, what his mental state was at the time. Do you have any other relevance? Is there any other relevance for this information other than that?
Your Honor, as the defense counsel just pointed out, they're going to be offering statements after the crime occurred in order to prove that the defendant had schizophrenia, answering that larger question. Whether it's a statement made to someone else or something the defendant did, such as search his internet history, is a distinction that doesn't matter in this case. Whether it's an action or a word said, this goes directly to rebut the fact that he had schizophrenia in the first place. Because our theory is that someone who has schizophrenia would not be able to have the state of mind to search on the internet specific things about covering up a murder.
Okay. Mr. Craig, I tend to agree with you. Mr. Hitchcock, your objection is noted. Were it my client, I would also be objecting to this information. However, I do believe that the probative value is high enough that it is not substantially outweighed by the prejudicial effect, although there is a prejudicial effect. And after conducting that balancing, I will overrule the objection and I will allow that exhibit to be admitted and you can publish it for any purpose. And we are back in the presence of the jury.
Now, detective, on the right here, there's the settings page. Whose name is that under there?
This defendant's.
Detective, now I want you to focus on the left-hand side, the search history. If you could please read for the jury what the defendant searched on October 18th.
Countries that don't extradite for murder charges, how to get rid of a body, will bleach, destroy a body.
See any spelling errors there, Detective?
I do not, sir.
Thank you, Ms. Gubernick. You can take that down. You mentioned you searched the defendant's car. I want to turn your attention now to Exhibit 22, page 99 of your electronic finder.
Yes, sir, I'm there.
What are you looking at?
This is one of the photographs we took of the interior of the defendant's vehicle.
Your Honor, I move for the admission of Exhibit 22.
Is there any objection, Mr. Hitchcock?
No objection, Your Honor.
All right, 22 will be admitted. You said 22?
Yes.
Okay, 22 will be admitted. And you may publish whenever you'd like.
Detective, was this one of the photographs you took while searching the defendant's car?
Yes, sir.
And what items do you see here?
As pictured, we found black trash bags, bleach, as well as a shovel that was covered in some dirt, and that's the handle of the shovel that's coming towards the photo.
Thank you, Ms. Gubernick. You can take that down. Detective, is the person who confessed to you killing and burying Nathan in the courtroom today?
Yes, sir. He is the man in the checkered button-up shirt.
Let the record reflect the detective has identified the defendant.
And I will acknowledge that the defendant has been identified constructively, and I will consider that and will not entertain any motions later on that he was not identified. So the defendant has been identified. Thank you.
Nothing further, Your Honor.
Okay. Let's just take about 5 seconds to make sure that our jurors can, I just want to make sure that they get their thoughts together about Mr. Craig's presentation. And then Mr. Hitchcock, if you are ready for your cross-examination, you can begin whenever you're ready.
I am, Your Honor.
All right.
Detective, you think my client is a piece of shit who'd be better off dead, right?
I said that at the end of the interrogation. That's correct.
That's right. That's what you told him immediately at the end of his interrogation.
Yes, I lost control of my emotions.
You lost control of your emotions.
Yes, sir.
Now, this interrogation, it wasn't the first time that you met the defendant, was it?
No, sir.
You and your kids played soccer, right?
That's correct.
They played soccer with the defendant's son.
That's correct, sir.
So you would see them at soccer games and soccer practices.
Yes, sir.
But even then, you didn't like the defendant, did you?
I'm not sure what you mean by that.
Well, you thought he was socially awkward.
I did, sir.
That he didn't fit in with other parents.
Yes, sir.
That he was hard to have a conversation with.
Yes, sir.
Now let's turn to the defendant's behavior during the interview. Now, during the interrogation, you'd characterize it as a normal interview, right?
I did.
And that nothing that Mr. Ray said was odd?
That's correct.
All right. Well, Your Honor, permission to publish portions of Exhibit 3 admitted on direct examination?
Absolutely. You may publish any exhibit that's been admitted at any time that you need to in your presentation.
Yes, Your Honor. Well, let's take a look and see whether or not that's true. On page 41, lines 19 through 20, it states, question, what were you and Nathan doing? Answer, are you from the CIA? You're from the CIA, aren't you? Nothing odd here?
That's correct, sir.
Okay, well, how about this one then? On page 42, lines 5 through 7, it says, question, what happened to your laptop? Answer, it was because she tricked him. She tricked him to do it. I know it. She tricked him to spill the juice on it because she wanted to take him away from me. And excuse me, I missed part of it. It was they told me she tricked him. Nothing strange there either?
In the context of an interview? No, sir.
Now, the defendant mentioned someone named they, right?
He did, sir.
You don't know who they are.
I do not.
You don't know who he's referring to when he says this ambiguous they.
No, sir.
And that's not even the only time that he mentions this undefined they, is it?
I don't believe so.
That's right, because further on down the page, you ask question, how did that make you feel? Answer, I didn't mean to. You have to know how sorry I am. You have to know how ashamed I am. You have to know how sorry I feel. I would never have done it if they hadn't told me to. They told me to. They told me that she tricked him. Nothing out of the ordinary here either, I suppose.
No, sir.
All right, detective. Let's talk about what you did after conducting this interrogation. As you mentioned, all interrogations are recorded, right?
That is correct.
But in this case, we don't have that recording.
We do not, sir.
Because you decided not to preserve it,
That's correct.
even though you could have.
That's correct.
You made the decision not to preserve the recording after conducting this interview, right?
That is correct.
And to be clear, during the interrogation, Mr. Ray didn't confess to petty theft, did he?
No, he did not.
He didn't confess to a DUI.
He did not.
He confessed to strangling his son, mentioning the CIA and voices, and you decided not to preserve this recording?
He confessed to strangling his son. That's correct. And I did not preserve the recording. That's correct.
A detective, when you were doing this interrogation, it was just you and Mr. Ray in the room, right?
Yes, sir.
As far as you know, nobody was watching while it was going on.
That's correct.
As far as you know, nobody ever watched the recording before it was deleted 30 days later.
To my knowledge, that's correct.
Now, that transcript, it records what was said during the interrogation, right?
Yes, sir. Yes.
But the transcript, it doesn't record screaming, does it?
It may not catch that.
Does it record crying?
It may not catch that either.
Well, you reviewed the transcript, right?
That's correct.
You said that during the interrogation, Mr. Ray was crying.
That's correct.
And nowhere in the transcript does it say the word crying.
That's correct.
Does it catch shaking, movement?
It would not, sir.
Does it catch body language?
No, sir.
So in short, while the transcript records what Mr. Ray said, it doesn't record how he was behaving.
That's correct.
And the only way we can know how he was behaving without a copy of that recording is from someone who saw the behavior firsthand, right?
That's correct.
In this case, that's you.
Yes, sir.
As far as we know, you're the only person who could testify as to how Mr. Ray was behaving in that interrogation room, aside from Mr. Ray, right?
Besides from Mr. Ray, that's correct.
And Detective, you've had 2 years to think about what you would tell this jury here today, right?
Yes, sir.
2 years to think about your testimony, knowing my client is pleading a defense of insanity.
It's been 2 years since the interrogation. That's correct. I'm not sure when I was notified about the insanity.
But Detective, you think my client is a piece of shit who'd be better off dead. Withdrawn. No further questions.
As he did withdraw, I will sustain it. I'll sustain the objection. I'm assuming I couldn't hear exactly what the basis of the objection was, Mr. Craig.
He was asked and answered, Your Honor.
Asked and answered. I'll sustain on asked and answered. Do you have any redirect?
Very briefly, Your Honor.
All right.
Detective, did you speak with the defendant on October 16th?
No, sir.
What about October 17th, the day he killed his son?
No, sir.
So all those quotes about the CIA and them, when did those occur in the context of your investigation?
It was after we had arrested him.
Nothing further.
Okay. And as the rules of this jurisdiction do not allow for recross examination, is the Detective Booth, is he allowed to be excused?
Yes, sir.
Okay, perfect. Detective Booth, you are excused. Thank you. If the prosecution will please call their next witness.
Yes, Your Honor. The prosecution calls Dr. Mac LaGreca.
Okay, Dr. Mac LaGreca. All right, Dr. LaGreca, you have been previously sworn. You are still under that oath, and Ms. Maurer, you may continue whenever you're ready.
Dr. LaGreca, what do you do for a living?
I'm a forensic psychiatrist.
Did I hire you to independently examine the defendant's mental health in this case?
Yes, you did.
And do you have an opinion as to whether the defendant was experiencing a severe mental illness that could have prevented him from understanding the nature or wrongfulness of strangling Nathan Ray?
Yes, I do.
Before we get to your conclusions, please tell the jury about your studies in psychiatry.
Of course. I obtained my medical degree from Penn. Then I went on to specifically study psychiatry and specialize in forensic psychiatry. I became board certified in psychiatry in 4 states, including West Carolina.
Does being board certified mean that you are nationally recognized in your specialty?
Yes, it is essentially the highest certification a psychiatrist can receive. For forensic psychiatry, you have to complete the required residency training and pass an extensive test by certain state and national medical boards.
And after getting certified, did you go on to treat patients?
I did. I opened up and ran my own private practice for 13 years. I worked with patients with a wide variety of mental disorders, that including schizophrenia.
Now, you said you ran your own private practice. Are you still treating patients?
I am. I still treat patients once a week, but now I'm in charge of West Carolina School of Medicine's Forensic Psychiatry program. That involves supervising medical students and teaching courses on mental health and the legal system.
Dr. LaGreca, have you been recognized as an expert in any court before this one?
Yes, I have been an expert witness in 7 criminal cases prior to this one, 3 of which involve schizophrenia.
Your Honor, I offer Dr. Mac LaGreca as an expert in schizophrenia and forensic psychiatry.
Mr. Barrett, you have any objection to that?
No objection as to Dr. LaGreca's qualifications. When she comes to conclusions, there may be objection there.
Okay. If you believe that she is going outside of her expertise, you will be free to make an objection at that time, and I will rule at that time. For now, I will accept Dr. LaGreca as an expert in forensic psychiatry, and you may continue whenever you'd like, Ms. Maurer.
Doctor, please tell the jury everything you reviewed in this case to analyze the defendant's mental health.
Okay. I reviewed all the police reports, the interviews, medical information, and the report of the psychiatrist hired by the defense.
What about interviewing the defendant?
I asked to do that, but the defense refused.
Dr. LaGreca, the defense has obtained a psychiatrist who is claiming that the defendant was suffering from schizophrenia at the time he killed Nathan. What is schizophrenia?
Schizophrenia is broadly characterized by someone's withdrawal from reality and personal relationships into fantasy and delusion. They experience hallucinations and/or start exhibiting inappropriate emotional behavior.
Did the defendant have schizophrenia?
Objection, Your Honor. Improper conclusion under 702. And if we may move to a constructive sidebar outside the presence of the jury.
Sure, we're outside the presence of the jury. Ms. Maurer, you have a response to that?
Your Honor, under 702, an expert may provide an opinion given that it is supported by sufficient facts or sufficient data, as well as reliable methods. Dr. LaGreca reviewed the expert's report in the defense's case. Dr. LaGreca reviewed reports of friends and family, and Dr. LaGreca reviewed, as she just testified to, the defendant's medical history and everything essentially that Dr. Riley reviewed, except for having to personally interview the defendant because she was not able to or not allowed to by the defense. Those are certainly sufficient bases for her to conduct an opinion.
And Ms. Maurer, I tend to agree only because I accepted her as an expert in forensic psychiatry, and I do believe she can diagnose schizophrenia, but I will allow Mr. Barrett to maybe explain a little bit more what you have the objection to.
Yes, Your Honor. We object under prongs B and C, the insufficient facts or data and using a reliable principle or method. As for B, this is insufficient facts or data. This doctor did not interview Mr. Ray, never spoke to Mr. Ray, and never saw Mr. Ray, either in person or any footage of Mr. Ray's behavior. The doctor didn't talk to anyone who knew Mr. Ray, didn't ask any follow-up questions about malingering or schizophrenia to any of these people. Instead, the doctor merely read some documents. This is insufficient facts or data. And as to prong C, the doctor just stated on direct examination that she reviewed material. She didn't say any principle or method that she used. It's this court's duty as gatekeeper to determine whether or not she used a reliable principle or method. And as she didn't actually articulate any method used, my objection stems from that as well.
Okay, I'm going to overrule on C, on the C part. On B, I will allow you one of two things. You may take her on a voir dire right now, if you would like, or you may ask those questions on cross-examination to test her opinion. And you can do either one. If your voir dire is successful, I may reconsider my ruling allowing her to testify it. If you'd like to just use those questions on cross-examination, that's fine as well. Which one would you like to do?
Your Honor, we'll do a brief voir dire.
Okay, then I'll allow you to do that. We're outside the presence of the jury.
Dr. LaGreca, you relied on documents when forming your conclusions, correct?
Yes.
You weren't
It's provided to me, sorry.
You weren't at the traffic stop with Officer Wentz.
No.
You weren't in the interrogation room with Detective Booth.
No.
You never reviewed any footage of this interrogation.
No.
You never interviewed Mr. Ray.
I wasn't allowed to.
So that's a yes. You
So
never
that's a
interviewed
no.
Mr. Ray.
Yeah, that's correct.
You never spoke to Mr. Ray once.
No.
You never saw Mr. Ray before this trial, in video footage or otherwise.
That's correct.
You never talked to anyone who knew Mr. Ray.
No.
You were never able to ask any follow-up questions about schizophrenia to anyone who knew Mr. Ray.
No.
You weren't able to ask any follow-up questions about malingering to anyone who knew Mr. Ray.
No.
You
And generally, you don't need those other collateral information for malingering.
Well, just to be clear, you didn't ask any questions about malingering to anyone who knew Mr. Ray.
No.
You made your conclusions based on reading some documents.
I made some conclusions based on another physician's evaluation. And I also used the DSM-5 to be able to get to my conclusions of both my opinion on schizophrenia and on malingering.
So, Dr. LaGreca, just to be clear, this report that you read, it was a document, right?
Yes, that's correct.
Thank you, Doctor. Nothing further for this voir dire, Your Honor.
Thank you, Mr. Barrett. Ms. Maurer, would you like to respond to that? I guess his specific objection under B, that she has insufficient facts or data.
Your Honor, first of all, I would like to reiterate it was the defense counsel's decision to prevent my expert from interviewing the defendant.
Noted.
And second of all, defense counsel has created their own standard. Nowhere in the rule does it say that they must rely on an interview with a defendant in order to form their conclusion.
And I tend to agree with you, Ms. Maurer. I am going to allow her to give this opinion. Mr. Barrett, I do know that we have some time constraints. So I will say that constructively, every question that you asked, I do believe that they are relevant. I believe that they're relevant to test her opinion. And you can constructively have had those on your cross-examination so that you don't have to go through them again. It may save you some time. If you'd like to ask them again, you're free to do that as well. But you and your counsel, your team will, or your advocates will be able to make that argument and closing argument as well, as if those questions were asked in front of the jury.
Yes, Your Honor. Just a quick question. May
Yes.
I reference the voir dire as though it happened in front of the jury
You may.
during the cross-examination?
You may. We will assume that all those questions have been asked in front of the jury, and you may reference it.
I appreciate that. Thank you, Your
Sure.
Honor.
All right, Ms. Maurer, you may continue, and we are back in the presence of the jury.
Dr. LaGreca, did this defendant have schizophrenia?
No, he did not. He was struggling with anxiety, which is a very common condition.
Would anxiety inhibit a person's ability to know right from wrong?
No.
Or prevent a person from understanding what they were doing?
No.
Let's refocus on schizophrenia for a moment. At what age do people typically start to show signs of schizophrenia?
Symptoms typically begin to manifest between the ages of 18 and 22.
This defendant is 34 years old. In his first 22 years of life, was he ever seen by a doctor for any type of mental health problem?
No.
Let's go to 2010, when the defendant was 23 years old. Was he seen for any issues then?
Yes, in the military.
What were his symptoms while he was in the military?
The defendant said he suffered from depression, anxiety, and trouble sleeping, none of which is uncommon for military personnel under high stress.
How long, if at all, was the defendant monitored in the hospital for his symptoms?
I believe he was monitored for 3 days in the hospital.
And what was his diagnosis at the end of those 3 days?
General anxiety disorder.
At that time, was the defendant considered a danger to himself or others as a result of his anxiety?
No, his doctor determined that he was not a danger in any way.
And this doctor, who diagnosed him with anxiety and ruled that he wasn't a danger to himself or others, is this the same doctor hired by the defense who is now claiming the defendant had schizophrenia?
Yes, it was the defense's psychiatrist in this case, Major Riley.
From the time this defendant left the military until Nathan's murder 8 years later, did he ever visit a psychiatrist or psychologist?
No.
Was he ever hospitalized?
No.
During that time, what was happening in the defendant's life?
He held a steady job and got married.
Doctor, when was the only time this defendant did receive a diagnosis of schizophrenia?
In January 2020.
How long after the murder was that?
I believe it's over a year.
Is there a resource that all psychiatrists use to evaluate whether someone has schizophrenia?
Yes, it's called the DSM-5. It's called the Diagnostic and Statistical Manual of Mental Disorders, 5 being the most current and up to date. And this is our gold standard, setting forth the reliable principles and methodologies for diagnosing different mental illnesses.
Your Honor, let the record reflect that I am publishing a demonstrative pre-trial agreement with opposing counsel.
Okay, Mr. Barrett, have you seen this demonstrative?
Yes, Your Honor, we did.
Okay, Ms. Maurer, you are free to do that and use it as you wish. If you have any objections, just make them and I'll rule.
Yes, Your Honor.
Doctor, the first part of the DSM diagnosis for schizophrenia contains a list of symptoms. How many of these symptoms must a person have for the diagnosis?
So an individual needs to have 2 out of the 5 symptoms over a month or longer. So even if you had one of these 5 symptoms at any given time, for a period shorter than a month, you wouldn't fit the diagnosis.
Let's talk about the first symptom. Was the defendant experiencing delusions?
No, the only evidence of the defendant's so-called paranoia is about his wife having an affair with their neighbor and leaving him, all of which was actually true and ended up happening.
If someone is paranoid about something that turns out to be true, can they still be considered delusional?
No, so delusions are unshakable beliefs in something that is not true or not based in reality. His wife admitted to having the affair as he thought, and she did eventually leave him and move out.
Now, looking at the second symptom, is there any proof that this defendant was experiencing hallucinations?
No, it was never established that he was hearing the kind of external sounds that are audible to everyone around him, which are more characteristic of schizophrenic voices. Rather, he seemed to describe worrisome internal thoughts that are more characteristic of anxiety, of which he was already diagnosed.
What about seeing things that aren't there?
In 2010, he specifically denied having any visual hallucinations, and no one close to him reported these symptoms. He did report visual hallucinations eventually, but not until after he killed his son and after his arrest.
The next symptom is disorganized speech. Is there any evidence of that from any witness or record?
No, there was nothing to suggest he was making up words or speaking disconnectedly from his thoughts. Detective Booth and Major Riley even said the defendant spoke coherently when they talked to him.
Is there any evidence that the defendant was exhibiting the fourth symptom, grossly disorganized or catatonic behavior, for a month or more?
Mm-hmm. There is only evidence of there's only evidence of this catatonic behavior occurring once during the course of his arrest, when the police officer reported that the defendant acted zombie-like for a few moments as he was getting out of his car. But this symptom did not appear for a month or longer, so it does not meet the requirement.
The fifth bullet lists negative symptoms, such as difficulty managing emotions. Did the defendant claim to have any of those?
To an extent. The defendant claimed that before he killed Nathan, he was experiencing trouble sleeping, crying, angry outbursts, and some other indicators of significant stress and anxiety. This is not surprising considering he was having marital problems and had a diagnosis of GAD, or general anxiety disorder.
Dr. LaGreca, the second factor under the diagnosis for schizophrenia talks about impairment in one of three major areas of functioning for a significant period of time. Was the defendant experiencing impairment at work?
No, he held a steady job at Computerland for 8 years, never late, never had a formal complaint. His boss even described him as a fantastic employee.
Now, another area under this is impairment in interpersonal relations. Now, we know the defendant had been separated from his wife for a period of over a year before the murder, but what did he and his wife agree to do about custody of Nathan?
They cooperated and agreed to share custodial time with Nathan each week.
Lastly, was there any long-term impairment to the defendant's self-care?
No, Major Riley cited several isolated accounts of the defendant's poor hygiene in her analysis, but there are just as many accounts of him appearing well dressed and groomed, such as during his interview with the prison psychologist and even Major Riley herself. Nor was there any reports of him at work appearing unkempt per his boss, even on the day before Nathan's murder.
As I said, the defense psychiatrist in this case has diagnosed the defendant with schizophrenia. Under the DSM requirements, as we've just reviewed them, is that diagnosis correct?
No, he doesn't meet any of the first set of symptoms, let alone two of them, like it requires.
Doctor, is there a diagnosis that does match the defendant's behavior after the murder of Nathan?
Yes, it is called malingering.
And please explain, what is that?
It's when someone fakes physical or psychological symptoms because they're motivated by something external. It could be as simple as wanting attention at the hospital, but is much more likely to occur in the context of something major, like wanting to avoid military duty or a criminal prosecution.
The DSM page for malingering contains a list of 4 factors. Of those 4 factors, how many do you need to diagnose malingering?
Having any combination of the listed criteria strongly suggests the diagnosis.
And how many did this defendant meet?
3 of the 4.
Doctor, I want to start with the first factor. Please explain medico-legal context.
The defendant was evaluated during and after a criminal case where there was an external incentive for him to have schizophrenia to avoid prosecution or conviction.
What about the second factor, discrepancies between a patient's claimed disorder and objective findings?
Yes, this was present. We have a lot of collateral information, like police reports, medical reports, and third-party interviews that suggest the defendant did not have symptoms such as CIA concerns prior to the murder.
And the third factor, was the defendant uncooperative during his evaluation with his own defense psychiatrist?
Yes, he was angry and combative throughout the interview, specifically when she called him out on inconsistencies in his story.
Dr. LaGreca, you've explained that the defendant met 3 out of the 4 factors for a diagnosis of malingering. What does the defense doctor say about the possibility that this defendant was malingering?
Major Riley stated that in her report that she couldn't rule it out for this defendant.
Your Honor, permission to mark this demonstrative as State's Exhibit A and preserve it for closing.
Yes, you may. The only thing that I would ask Ms. Maurer is that if Mr. Barrich would like to refer to it, I don't know if he has a copy, but I guess if you could facilitate that for him, just as if the defense has a demonstrative, I want the prosecution, if they need for any reason to refer to it, I'd like you to make sure you facilitate that for them, just like if we were in an actual courtroom.
Yes, Your Honor.
And it will be so marked.
Thank you, Ms. Gubernick. Dr. LaGreca, do you hold your conclusion that the defendant was malingering, along with all the other conclusions you've given to this jury today, to a reasonable degree of psychiatric certainty?
Yes.
The insanity defense requires that the defendant lacked the ability to understand the nature of his actions or to understand right from wrong. Did the defendant ever say to anyone involved in this case that he did not know that strangling his son was wrong?
No, he said he had to punish his son.
The jury heard about the defendant's confession to Detective Booth. Did he ever say that he did not understand that he was putting the belt around Nathan's neck and strangling him?
No, he said he walked into his own bedroom, got a belt from his closet, took time to even calm himself down, but still went back into Nathan's bedroom and put the belt around Nathan's neck and pulled.
Nothing further.
Cross-examination, Your Honor.
Yes, Mr. Barrich, if we could give about, I don't know, 10 seconds for our evaluators to make their decisions if they need to, use that time. And then I think about 3 more seconds and you can start whenever you're ready.
Thank you. May I proceed, Your Honor? I think that's about enough time. Hello, Dr. LaGreca.
Hi.
I want to start about talking about whether you had enough information to come to your conclusions. Now, you concluded that Mr. Ray is malingering, right?
Yes, that's correct.
In other words, you concluded Mr. Ray is faking the symptoms of schizophrenia.
Yes, that's correct.
Now, before his son's death, Mr. Ray attended 4 sessions with medical professionals that you're aware of.
Yes, I am aware of those.
You weren't there for any of them.
No, but as you said, there were medical professionals.
And you weren't there for any of them, correct?
No.
After his son's death, Mr. Ray spoke with multiple police officers.
Yes,
You weren't there for any of these conversations either.
I was not.
Instead, you read about them, right?
That's correct.
But Dr. LaGreca, you'd agree with me, there's a difference between a written transcript and being in the same room.
There is a difference, yes.
A written transcript, it doesn't show body language.
Yes, that's correct.
A written transcript doesn't show facial expression.
It does not.
It doesn't show tone of voice.
It does not.
Now, this is the 8th time you've been retained in a criminal case, correct?
Yes.
But it hasn't been a 4-4 split between prosecution and defense.
You're right about that, yes.
6 out of 7 previous times you've been retained by the prosecution.
Yes.
After today, that's 7 out of 8.
Yes.
I want to talk a bit more about your conclusions. You believe that Mr. Ray was not suffering from schizophrenia.
I do believe that, yes.
But it's true that a person's more likely to actually suffer from schizophrenia if they're showing several signs and exacerbating factors.
That is linked to worsening schizophrenia, but if there's a prior diagnosis as well.
So that's a yes to my question. A person who's showing several signs and exacerbating factors of schizophrenia is more likely to actually have schizophrenia compared to someone who's not showing those signs.
Yes, it's possible.
Let's talk a bit about those signs and exacerbating factors. Your Honor, permission to display demonstrative already shown to opposing counsel.
Yes, and under the same rules as I talked about, at any time, if she would like to refer back to that in her redirect, or I guess at any time during her cross, you would just be able to make it available for her.
Of course, Your Honor.
Sure. Go ahead.
Now, it's true that anxiety disorder can worsen and lead to a more serious mental illness, right?
That is a connection. It's not necessarily one-to-one. It's possible, but yes.
So that's a yes to my question. It can worsen and lead to schizophrenia.
Yes, I said that.
Mr. Ray had a diagnosis of anxiety disorder before October 2018.
That's correct. It's a very common disorder.
So that's a yes.
Yes, I did say, yeah.
It's also true that childhood trauma makes a person more likely to develop a severe mental illness like schizophrenia.
It's possible, yes.
Mr. Ray suffered from childhood trauma.
He did, yes.
It's also true that a family history of severe mental illness makes a person more likely to develop a severe mental illness like schizophrenia.
Yes, depending on what the initial diagnosis was at the time.
In your own words, a severe mental illness in the family makes that more likely, right?
Yes, to develop a severe mental illness. Yes.
Mr. Ray's mother suffered from a severe mental illness.
That's correct. We do not know the diagnosis, however.
We do know it was severe.
We do know that. Yes, correct.
Now, I want to talk about the DSM-5. You'd agree that's a reliable authority on diagnosing schizophrenia?
Yes, that's a gold standard. All physicians use that for diagnosing any medical condition.
So the DSM-5, it states that delusions are a sign of schizophrenia.
Yes.
Now, Mr. Ray, he visited Dr. DiGiuseppe in 2016, 2018, right?
Yes.
He told the doctor he feared his wife was having an affair.
Yes.
He then accused the doctor of taking his wife's side.
He did, but I can understand why he may have done that.
So that's a yes to my question. He accused the doctor of taking his wife's side.
Yes.
He then accused the doctor of talking to his wife behind his back.
Yes, with his power, with the way that yes.
He then accused the doctor of listening in on his phone calls.
Yes, he did say that.
Dr. LaGreca, this visit happened before October 2018, right?
Yes.
Now, the DSM-5, it also states that hallucinations, that's a sign of schizophrenia.
Yes.
Mr. A said he started hearing voices when he was a child.
Yes, but he didn't report that in 2010 when he spoke to his psychiatrist at the time, for which he did a full evaluation of him.
Doctor, my question wasn't about the timeline. It was just Mr. Ray said he started hearing voices when he was a child, and that's true.
Yes, that's correct, but the diagnosis is important to talk about timeline.
We're not talking about the timeline right now, doctor. I'm sure you'll have a chance to discuss that on redirect.
Okay.
Now, Mr. Ray also said he started hearing voices again in 2015.
He did report that to his defense psychiatrist.
And he said in 2018, those voices came back.
Yes, again, after his arrest.
So that's a yes to my question, right?
I did say yes, yes.
Now, Dr. LaGreca, during his interrogation, Mr. Ray said multiple times, they told me she tricked him, correct?
He did say that.
You never saw the footage of this interrogation?
No.
Thank you. Nothing further, Your Honor.
Okay, Ms. Maurer, do you have any redirect?
Briefly, Your Honor.
Okay, let's give about 5 seconds before you start, just for our evaluators so they can evaluate Mr. Barrett. And then you can go ahead after that 5 seconds and we'll be ready.
Dr. LaGreca, did Mr. Ray consistently deny experiencing hallucinations up until 2018?
Yes, he did. So he denied hallucinations at his initial evaluation, never reported them to his primary physician at any point over those few visits, and even at the time of his evaluation while in prison, did not report any hallucinations whatsoever.
When did he finally report hallucinations?
This was all after his arrest.
No further questions.
Okay, Dr. LaGreca, thank you. You are excused. We appreciate your participation and you are free to go. Now I'll ask the prosecution. Do you have any other witnesses to call?
No, Your Honor. The prosecution rests its case on the chief at this time.
Okay. Defense, is there any motion that you would like to make outside the presence of the jury?
No, Your Honor. Because we're bringing an affirmative defense today, we won't be arguing a Rule 29 motion.
Okay, that is just fine. Phil, I don't know if you can hear me, but is it permissible on our timeline to give them a break?
We've got plenty of time. Up to your discretion, Judge.
Okay, so why don't we take about, let's say, 7 minutes. Everybody, y'all can refresh, get ready, and then we will start with the defense case in chief. I'm on a central timeline, so I'm sorry, I'm in central time, so I'm at 4:22. So I'm assuming y'all are at 5:22, or at least Philadelphia is at 5:22. So, okay, so what we'll do is we'll be back here at, let's just say 5:30 Philadelphia time.
Thank you,
Your Honor.
All right. All right, welcome back, guys. I guess if I could get an acknowledgement that my jurors are back.
And Judge, while we await that acknowledgement, can I just have our timekeepers unmute their audio and announce the times for each side?
Absolutely, that was the next thing I was going to ask. So thank you.
You're way ahead of me, Judge. That's why I picked you.
Thank you.
Yes, so we have that, and both sides have agreed on the times at this point. So the prosecution has 22 minutes and 57 seconds remaining, and the defense has 33 minutes and 24 seconds remaining.
Okay. Perfect. And let's see. I saw a couple acknowledgements from the jurors. I just want to make sure. I guess if y'all can do a little thumbs up if you haven't already. I saw Bradford.
Harry's here.
Okay, good. Perfect. Everybody's back. All right. I didn't want any juror to miss any of this because it's very good from both sides. So, okay. We are now at the defense case in chief. I understand the defense would like to call some witnesses. So, Mr. Hitchcock, I'm assuming you'll be the advocate for that?
Yes, I'll be the first one, Your Honor. We'll be calling Dr. Riley to the stand.
Okay, then Dr. Riley, if you could please come to the stand. Perfect. I see Dr. Riley. Now, Dr. Riley, you have been sworn previously, and you're going to be under that same oath. Mr. Hitchcock, you may proceed with your direct examination whenever you would like.
Yes, Your Honor. Good afternoon. Please introduce yourself to the jury.
Good afternoon. I'm Dr. or Major, depending on the situation, Shane J. Riley.
What do you do for a living?
I'm a forensic psychiatrist.
How are you involved in today's case?
I was asked to determine whether Timothy Ray was exhibiting signs of schizophrenia or any other mental illness on October 17th, 2018.
Now, before we get to your conclusions, I want the jury to get a sense of your qualifications. Well, where'd you go to school?
I attended the Uniformed Sciences University School of Medicine for my medical degree, following which I was at Walter Reed National Military Medical Center for both my general psychiatry residency and my forensic psychiatry fellowship.
And how long have you been practicing?
Since 2002.
Are you published in the field of psychiatry?
Yes, I am. I have 15 published papers.
Are any of those 15 published papers specifically related to schizophrenia?
2 of them are.
Apart from your work in today's case, do you have any experience determining whether someone has schizophrenia?
Yes, certainly. That's standard in the field of general psychiatry and forensic psychiatry.
And just for full disclosure, doctor, are you being compensated for your time today?
Yes, I am.
The defense offers Dr. Riley as an expert in forensic psychiatry and schizophrenia.
Mr. Craig, any objection?
No objection, and we'll save our questions for cross.
Okay, then she is accepted in the fields that you have offered her in, and you may proceed.
Now, doctor, let's focus on your work for today's case. Was Timothy Ray a patient of yours?
He was in 2010 at Walter Reed.
When did you conduct clinical interviews with Mr. Ray?
Both in 2010 and also in 2019.
Other than those clinical interviews, what materials did you rely on in your work for today's case?
I relied on all the materials in the joint exhibit, as well as 3 additional interviews with Timothy Ray's father, ex-wife, and former boss.
What methods did you use to analyze these materials?
I reviewed all of them and compared them to the definition for schizophrenia in the DSM-5.
So is comparing the symptoms exhibited by an individual to those listed in the DSM a standard method in psychiatry?
Yes, of course.
Did you reliably apply that method to the facts and data of this case?
Yes, I did.
And finally, doctor, were the materials and methods that you used allowing you to form any conclusions to a reasonable degree of medical certainty?
Yes, they were.
Doctor, if you would tell the jury, what were your conclusions?
My conclusions were that Timothy Ray suffers from schizophrenia, and furthermore, that he was suffering from a schizophrenic episode on October 17th, 2018.
I want to break those apart for the jury, starting with your first conclusion about schizophrenia. But first, could you tell the jury what schizophrenia is?
Schizophrenia is a psychiatric disorder, falls under psychotic disorders, and it's characterized by both positive and negative symptoms.
Is every case of schizophrenia the same?
No, certainly not. It exists on a spectrum from very mild to severe and violent.
So do people suffering from schizophrenia always know the difference between right and wrong?
No, not always.
What does it depend on?
It would depend on the severity of the episode that they're having.
Now, a minute ago, you said that you used the DSM to diagnose Mr. Ray with schizophrenia. How'd you do that?
Well, I compared the signs and symptoms Mr. Ray was having to those set out in the DSM-5.
How do you make a diagnosis of somebody under the DSM of schizophrenia?
Somebody needs to have at least 2 of the 5 symptoms for a period of a month or longer.
And how many of these symptoms did you conclude Mr. Ray was having?
I concluded he was having 3: delusions, hallucinations, and negative symptoms.
All right, doctor, let's break that down for the jury. I understand you prepared a chart to assist with your testimony today, right?
Yes, I did.
Your Honor, permission to display Dr. Riley's demonstrative. It was shown to opposing counsel pre-trial.
Yes, you may have that permission.
Doctor, let's start with the first symptom we see here, hallucinations. What are hallucinations?
Hallucinations are perceptions that aren't based in reality.
Why did you conclude that Mr. Ray was having hallucinations?
Well, because he reported seeing things that nobody else was seeing and hearing voices that nobody else was hearing.
How long had Mr. Ray been exhibiting hallucinations?
He reported that he'd had hallucinations as far back as 2010 for the auditory or heard ones, and since, I believe, 2017 for the visual ones.
All right, let's move on to delusions now. What is a delusion?
A delusion is a fixed false belief not based in reality.
Why did you conclude that Mr. Ray was having delusions?
Well, because throughout his interactions, he accused several people of being CIA, following him for being a terrorist. And he also reported that he feared his wife and son were conspiring to cut him up and leave him.
How long had Mr. Ray been having delusions?
Since 2015.
All right, doctor, turning to the last symptom on the chart, something called negative symptoms. Could you tell the jury what you mean by that?
Negative symptoms are symptoms that prevent a person from functioning normally, or sort of the absence of symptoms, absence of proper grooming, absence of normal sleep, absence of normal behavioral regulation.
And why did you conclude that Mr. Ray was experiencing negative symptoms?
Because he reported several of the things that we described, and several people witnessed those things as well. His emotional outbursts, his trouble sleeping, and so forth.
How long had he been showing negative symptoms?
Certainly since 2017, and it worsened towards the end of 2017 and into 2018.
All right, doctor, now let's turn to your second conclusion. Now, without going into Mr. Ray's specific state of mind, were you able to determine if he was suffering from schizophrenia on the day that he killed his son?
Yes, my opinion is that he was.
How do you know?
Well, because he once again was exhibiting 3 symptoms: hallucinations, delusions, and negative symptoms.
What hallucinations was he experiencing that day?
He experienced voices telling him to kill his son, telling him his son was trying to sabotage him.
And delusions, what about those?
Well, that the CIA was out to get him, that his son was possessed by evil and needed to be cleansed.
What about negative symptoms? What of those was he showing?
Yes. At several points around that time, he exhibited poor grooming and some very serious emotionality, poor control of his emotions.
All right, doctor, stepping back, I'm no expert, but couldn't Mr. Ray have just been making these things up?
Yes, he could have, but it is my firm opinion that he was not.
Well, how confident are you that Mr. Ray was not, in fact, malingering?
Very. I've seen malingering quite a number of times in my career, and in this case, I concluded to a reasonable degree of medical certainty that he was not malingering.
Thank you, doctor. Your Honor, we have no further questions at this time.
Okay, we'll give a couple seconds, Mr. Craig, and then I guess enough time has passed. So I will invite you now to conduct your cross-examination of Dr. Riley.
Thank you. First off, you mentioned you have two separate titles. Would you prefer doctor or major?
I would prefer doctor, since that is the context in which I am here.
Okay, well, doctor, you just talked about malingering, and we can agree malingering means faking symptoms.
Yes, we can.
Now, Dr. LaGreca found that this defendant was malingering, and ultimately you couldn't rule that out.
Ultimately, I said I could not be certain, but to a reasonable degree of medical certainty, I am that he was not malingering.
Well, doctor, this defendant fits the profile of a malingerer.
He fits the profile of someone who is high probability, but I think we can all agree that probability does not mean that it is the absolute truth.
Well, let's go over that. Doctor, if someone's story has discrepancies, even about small details, that suggests malingering.
Sure.
And you called out this defendant because his story was inconsistent.
Yes, I did.
And doctor, when criminal charges are likely, the likelihood of malingering goes up.
Yes, it does.
Charge against this defendant is murder. It's the most serious crime there is.
Yes.
The more serious the crime, the higher the likelihood of malingering.
Yes.
Doctor, when a crime occurs, it's harder to say someone had schizophrenia without a previous diagnosis.
Well, it's harder, but certainly not impossible.
It's harder.
Yes.
This defendant wasn't diagnosed until January 2020, after he killed his son, correct?
Correct.
Doctor, when you diagnosed this defendant with schizophrenia, you didn't correctly apply those DSM principles you just talked about.
I believe that I did.
All right, well, we can agree that there are ultimately 3 factors for the DSM for schizophrenia, right?
Yes.
Right, there's that first factor, there's 5 symptoms you just talked about.
Yes.
And then there's that second factor, impairment for a significant period of time in a major area of functioning.
Yes.
Well, doctor, you didn't talk about that factor on direct examination.
I apologize for my oversight.
That's all right, but I just do want to go over your report. Now, if you could turn to page 56, Exhibit 11, if you're blind.
Oh. I'm sorry, I have not been asked to reference anything thus far. I will pull that up. You said that was page 56?
Mm-hmm.
Yes.
And that's your report.
My report from 2010 when I treated him.
No, this is your report from 2020 when you diagnosed him.
On
Your
page
Honor,
56?
if I may interject, this is Exhibit 9 on page 56. I believe opposing counsel is referring to page 58, Exhibit 11.
I guess, Mr. Craig, is that what you're referring to, or?
I think I think I looked at the wrong exhibit number for that one. Defense counsel is right about the page number.
Okay, no problem. So, Dr. Riley, if I believe that they want, what was the page that we were looking for, Mr. Hitchcock?
Page 58. It's the start of Exhibit 11. Is what I believe opposing counsel is referencing right now.
Okay, page 58, Dr. Riley, and I think we'll all be on the same page, and you can continue, Mr. Craig.
Now, doctor, this is your report from when you diagnosed the defendant.
Yes, this is.
You have several headings in that report.
Yes, I do.
To be clear, you knew this could be used at trial.
Yes.
You were complete and thorough in your analysis.
Yes, I was.
All right, well, I want you to turn to one of those headings on page 65. There's a heading called DSM.
Just a moment. Okay, yes.
And that's where you apply the DSM principles to this defendant.
Yes.
Now, in that section, you reference those 3 symptoms of the 5 first symptoms that you thought applied.
Correct.
Nowhere in that section do you mention impairment for a significant period of time in a major area of functioning.
Objection, Your Honor, hearsay.
The objection is hearsay. What is the response?
Your Honor, under Rule 705, I'm allowed to cross about hearsay.
I tend to agree, Mr. Hitchcock. What can you define, I guess, more clearly what you're objecting to specifically?
Well, Your Honor, they're bringing in the expert report to make it seem as though Dr. Riley is being inconsistent about her testimony today. And as a result, there's no inconsistency that's been elicited. She testified to the 3 symptoms that were included in her report. There's no real relevance to go into what the contents of the report were if they're proving them for the truth of the matter asserted for any other reason without admitting a document into evidence, which I believe both parties would agree is out-of-court statements being offered for the truth of the matter asserted. As a result, we don't see the point of this line of questioning, and asking about specifics of the document is hearsay.
And I do agree with that as far as the truth of the matter asserted. I think Mr. Craig, though, is using it to test Dr. Riley's opinion. I will allow it for that purpose. If you would like, I could constructively instruct the jury that it's only for that purpose and not for the truth of the matter asserted.
Your Honor, a limiting instruction would be useful, yes.
Okay, then I will make that instruction to the jury constructively, and I will overrule your objection to hearsay.
Doctor, returning to my question, nowhere in that section under the DSM do you mention impairment for a significant period of time, correct?
No, I do not.
And if you could turn back to page 64 in the section titled Principles.
Yes.
In that section, that's where you lay out the DSM principles that you used.
Correct.
You don't mention the second factor there either.
Correct.
Because, doctor, there were signs that this defendant could function just fine throughout his life.
There were signs of that, and there were signs that he had some trouble functioning.
All right, well, let's go over the signs that he functioned fine. He was able to graduate from college.
Yes, he was.
He graduated with honors.
Yes.
He got married.
Yes.
After they separated, his wife agreed to share custody.
Yes.
He held a job for 8 years.
Yes, he did.
And the boss at that job told you the way the defendant looked the day before he killed his son.
Yes, she did.
That he appeared normal.
Yes, to a lay person.
He wasn't the only one who, well, she wasn't the only one who observed his normal behavior. You saw the defendant in 2010 in the hospital for 3 days.
Yes, I did.
That time he denied having hallucinations.
He did deny that.
Speech to you was normal.
Yes, it was.
And you didn't think he was a harm to himself or others.
No. No, I did not.
And he was also seen by a doctor in 2019 in prison.
Yes, he was.
That doctor said he was able to answer her questions.
That is what that doctor reported.
And that he was conversing with her normally.
Yes.
Doctor, you know the jury has to decide in this case whether or not the defendant knew right from wrong, correct?
Yes, I'm aware of that.
After reviewing the file, you know the defendant didn't call the police after killing his son.
Correct.
He didn't drive his son to the hospital.
Correct.
That he buried his son in a shallow grave.
Yes.
And then he looked online for ways to get away with killing his son.
That is what that appears to indicate, yes.
No further questions.
Okay, Mr. Hitchcock, if we could just give a few seconds, and then you will be free to do a redirect. Well, first, do you have a redirect examination?
I do, Your Honor.
Okay, you may continue and you may proceed when you're ready.
Doctor, I want to touch on a couple points that opposing counsel made on cross-examination. Was the defendant still with his wife when the killing occurred?
No.
Did his wife ever tell you why they were separated?
Yes, she said that at some point in their marriage, he became a completely different person.
Now, additionally, the opposing counsel pointed out that he hadn't been diagnosed until after Nathan was killed. Does this mean that the diagnosis is unreliable?
Not necessarily. Psychiatric diagnoses do evolve over time. So it's not entirely unexpected that at a later time, a diagnosis would change.
And on a related topic, opposing counsel also mentioned that the defendant took a little while to report his symptoms. Does when someone reports their symptoms always mean when they're experiencing them?
No, certainly not.
Are there reasons why people may delay reporting symptoms?
Yes, fear of its implications for any number of things in their life, their career, their relationships, and just general societal stigma.
No further questions, Your Honor.
Okay. Defense, do you have another witness to call?
Yes, Your Honor. The defense calls Officer Wentz to the stand.
Mr. Barrett, welcome back. It's been a while since I've seen you. Okay, Officer Wentz, you have been previously sworn and you are under the same oath, and I don't have to swear you again. You'll just be under the same oath you had. And Mr. Barrett, you may proceed whenever you're ready.
Hello, Officer Wentz.
Good afternoon.
Could you please introduce yourself to the jury?
Sure. My name is Peyton Wentz.
What do you do for a living?
I'm a police officer right here in Skelton County.
What training did you receive to become a police officer?
I went through the typical police academy training. We learned about the laws of West Carolina, criminal investigations, patrol procedures. I also participated in the crisis intervention team. It's a special training program for dealing with individuals who have mental health issues.
Well, I want to talk about how you're involved in today's case. Do you know Timothy Ray?
Yes, I do.
How so?
I was the one who stopped Mr. Ray at a DUI checkpoint. This was right off of Route 22 on October 18th. This was the stop that ultimately led to his arrest.
Well, let's just take a step back. What were you doing right before you stopped Mr. Ray?
Before Mr. Ray arrived, it was just a routine night shift. My partner and I were sending people through the checkpoint like usual. We actually hadn't even made any arrests up until that point.
So when did you stop Mr. Ray?
That would have been around 9 p.m.
How did Mr. Ray look when you first saw him?
His hair was all messed up. His eyes were glassy. I saw stains on his clothes and I could smell his overwhelming body odor. It looked like he'd been in the car for days.
So what'd you do after seeing all this?
Well, it was a traffic stop. So I asked Mr. Ray for his license and his registration.
How did Mr. Ray respond?
He got antsy and he asked me why I needed them. When I told him it was just routine, he tried to tell me he had forgotten his wallet at home and that he didn't have his registration either.
What happened after he told you he didn't have that wallet?
Well, it was clear he had no idea what he was talking about. His wallet was sitting in the open right on his center console. So I pointed this out to him. He finally ended up taking out his license and registration and giving me both.
What'd you do after you got the license and registration?
I started walking back to my squad car to run his information and plates. On my way there, I looked through Mr. Ray's front and back car windows, just like I was taught.
Well, what'd you see through that front window, officer?
I saw trash all over the passenger seat.
How about the back?
Well, it was also a mess, but for a very different reason.
Your Honor, we're presenting Exhibit 22 to the jury, already in evidence. Officer Wentz, could you please tell the jury what you saw when you looked through that back window?
Sure. You can see here there's a dirty shovel. There's a couple bleach containers on the seat and several large trash bags that are sitting on a child's booster seat. And those things were all just sitting out in the open, just like the wallet was.
Thank you, Mr. Hitchcock. You can take that down. Let's go back to the traffic stop. What'd you do after looking through the back window of the vehicle?
Well, I had my partner run the information, and I went back to talk to Mr. Ray.
How did Mr. Ray react when you got back?
He started yelling, "Are you with the CIA?" I said no, obviously, but he kept yelling that he knew the CIA had been watching him because they thought he was a terrorist. He said he could hear the sirens of the CIA.
What'd you do after hearing all this about the CIA?
Well, I told him it was just a routine traffic stop. But because he was yelling and starting to get belligerent, I asked him to step out of the vehicle.
Did he comply?
Eventually, but he kept asking me for my CIA credentials. Again, I told him I was just a police officer. I even showed him my badge. He got out, but then he changed, I guess.
Officer Wentz, what do you mean changed?
Well, before he was frantic, but then he started moving really slowly, had a completely blank stare and wouldn't make eye contact at all. And then he started talking in this monotone voice, not directly at me, just to himself.
What was he saying?
At first, I didn't know. He kept muttering to himself over and over again. Then he looked up at me like he hadn't noticed me before and said, "I was just trying to get my son in shape and get him to admit what he broke. My son just needs to do jumping jacks."
Now, Officer Wentz, what happened after you heard this statement about the jumping jacks?
Well, then he started doing a jumping jack. I told him to stand still, but it didn't seem like he heard me. He started doing another and another. At this point, I had no idea what he would do next, so I actually pulled my gun and I yelled at him to stop.
Did he stop?
Well, he stopped doing jumping jacks.
What happened after he stopped doing jumping jacks?
His head started moving uncontrollably. He was kind of holding his hands over his ears like this. I was able to put handcuffs on him to restrain him, but then that rambling started up again in that same quiet, kind of frenzied voice.
So what did you do after seeing all this?
Well, at that point, my partner called me over. So I sat Mr. Ray down on a curb just a few feet from our patrol car. My partner said the plates had been flagged for a missing child report. So I had my partner keep a really close eye on Mr. Ray, and I went to radio it in. I described what happened at dispatch, and I expected them to send an EMT.
Who'd they send?
Well, about 20 minutes later, Detective Booth arrived on the scene.
What did Detective Booth do when he arrived on scene?
It was kind of strange. He told me to escort Mr. Ray to the station and get him set up in an interrogation room for an interview right away. I thought there would be an EMT called in so we could get him to a hospital.
Officer Wentz, what did you end up doing?
I followed orders. I put Mr. Ray in the back seat and then drove him to the station, then straight to the interrogation room, just like Detective Booth told me to do.
Thank you. Nothing further, Your Honor.
Okay. Ms. Maurer, I'm sure you have a cross-examination. I'll just give a few seconds and And you're ready to begin whenever you'd like to.
Yes, Your Honor. Officer Wentz, just so we're clear, you're not a doctor, right?
Definitely not, ma'am.
Okay. When the defendant first drove up to the checkpoint, he didn't try to drive right through it, correct?
No, he stopped.
He didn't crash into the curb either.
No, ma'am.
And he didn't drive into you.
No, thankfully.
Officer, the defendant didn't mention the CIA within the first few minutes of your conversation, did he?
No, not within the first few minutes.
Because as you just spoke about, the first few minutes were about whether he would give you his license.
Right. First, he said he didn't have it. It's there. Exactly.
And when you asked for it, he asked you why you needed it.
That's right. That's what he said first.
You explained why.
Obviously, it's a traffic stop.
He didn't seem happy.
No, I wouldn't say that he was happy necessarily.
And not only was he unhappy, he was being defiant.
Well, sure. Anytime someone tells you something that's clearly not true, I would associate that with defiant. Yeah.
Right. He lied and told you he didn't have his ID with him.
Right. It was weird. It was sitting right there. I didn't understand how he didn't know that.
After the defendant finally handed over his license and registration, you walked around his car.
Not quite. I walked back to my squad car, and on the way back to the squad car, I glanced through his windows like I'd been taught.
And you shined your flashlight right into his back seat.
Yes, ma'am. We're looking for weapons, any dangerous contraband, anything that can harm us.
And the light revealed trash bags.
Yes, ma'am. Strange, but not dangerous.
2 jugs of bleach.
Yes, ma'am.
And a shovel.
That's correct.
You then handed over the defendant's ID to your partner, or previously.
I'm sorry, could you repeat that one more time? I don't think I caught that.
You handed the defendant's ID to your partner.
That's correct, yes.
And it was only after you saw these tools and had his identification that he started accusing you of being CIA.
Yes, ma'am. When I returned to the vehicle, he mentioned the CIA.
And it wasn't until after that he started doing jumping jacks.
That's right. That's after I asked him to get out of the vehicle.
Officer Wentz, part of this case centers on whether the defendant can prove he was insane at the time he killed Nathan. You were with him at this checkpoint for about 30 minutes, right?
That sounds about right. It may have been a little bit longer than that, but roughly 30 minutes.
You then drove him to the police station as well.
Yes, ma'am.
And sat with him briefly at headquarters.
Briefly. I didn't conduct the interview, but I sat with him until Detective Booth arrived.
And in all that time, he never said to you, I didn't know what I was doing.
No, he said some strange things, but not that, ma'am.
He never said, I didn't know it was wrong.
He said that his son was in a better place, but he didn't say that he didn't know what he was doing was wrong. That's correct.
And he never said, voices made me do it.
No, ma'am, he didn't say that.
What he did say to you, Officer Wentz, was, I messed up.
That was one of the things that he said that night. Yes, ma'am.
No further questions.
Okay. Mr. Barrett, are you going to have a redirect?
No redirect, Your Honor. May the witness please be excused.
The witness may be excused. Okay. I will now ask the defense to call their next witness.
With that, the defense rests, Your Honor.
All right. So we have come to the time of closing arguments. I know we didn't say it in housekeeping, but you can believe that I have constructively read the jury charge prior to the closing argument, and you will be able to use the jury charge in my instructions in each of your arguments. I would like, I don't know as far as the tech goes, if y'all need a little time to set it up, I would like a time check from our timekeepers just to make sure that each advocate knows how long they will have for their closing argument.
Your Honor, if I could also request a 2-minute warning at the end of my closing, that would be great.
Okay, and the way that I'd like to do it is for your timekeeper to just, I guess, flash in at your 2 minutes. And I think if that's acceptable to you, then you'll be able to see your timekeeper when they flash up, and you'll know that that's your 2-minute warning, if that's okay.
Yes, Your Honor.
Okay. So my timekeepers, I don't know who's who, but can y'all come in real quick and tell us how much time we have?
Yes, Your Honor. Sorry, we were just conferring on the time.
Oh, yeah.
We have, the prosecution has 13 minutes and 1 second remaining.
Okay.
The defense has 15 minutes and 6 seconds remaining.
Okay, I will assume that will be enough time for each. Ms. Maurer, you will be free to use whatever remaining time you have for rebuttal. If you have remaining time, you don't have to ask for it, and I'll just assume that whatever time is left is what you'll be using. Do you want, do you want a warning on your rebuttal?
Yes, Your Honor, 1-minute warning.
Okay, and so if the timekeeper understands that, you will flash in for Ms. Maurer's 2-minute warning in her close, and then you will flash in, just show your face at the 1 minute when she has 1 minute remaining in her rebuttal. Obviously, if she never gets to 2 minutes in the close, you'll only be flashing in once. Okay, other than that, is there any time, maybe just a couple minutes that you guys need to set up, or are y'all ready to go?
Just a moment to switch my camera, Your Honor.
Sure, you can have that. I'll give about 2 minutes, and then I'll come back on the screen, and then we'll be ready to start.
Judge, can I just have the timekeepers announce their respective times just once more before we proceed?
Sure, absolutely.
Yes, so the prosecution has 13 minutes and 1 second remaining. The defense has 15 minutes and 6 seconds remaining.
And we are in agreement on that time. We conferred and agreed that that is the proper time.
Perfect. Phil, you good with that?
Sounds good, Judge.
Okay, 2 minutes.
May I proceed, Your Honor?
Oh, you're ready to go. Great, perfect. Yes, ma'am. Ms. Maurer, you can proceed with the prosecution's closing argument.
I messed up. I pulled the belt until he stopped screaming, until he stopped moving. These words prove that the defendant made conscious choices. These words, physical evidence, and the science are proof of murder with malice aforethought. Choice 1, searching for a weapon, choosing a belt, and placing it around the neck of his 6-year-old son, pulling it tighter and tighter until he had no breath left. Choice 2, looking to the internet, not searching for the nearest hospital, but for countries that don't extradite for murder charges. How to get rid of a body? Will bleach destroy a body? Choice 3, putting Nathan into his car and gathering supplies. Not 1, but 2 jugs of bleach, trash bags, and a shovel. Choice 4, driving to the woods, a place where discovery of the body would be unlikely, and shoving Nathan into a garbage bag, then dumping him in a shallow grave and shoveling dirt on top. Finally, loading each supply back into his car and driving off. These are the defendant's conscious choices, proven by the physical evidence and confirmed by the autopsy, which showed bruises across the front and sides of Nathan's neck, consistent with being caused by a belt. What is murder with malice aforethought? The judge just told you. It happens when a person chooses to kill and then follows through. It can be the choice to keep hurting a child cruelly or uncaringly, until death occurs. The standard for the prosecution to prove this to you today is beyond a reasonable doubt. Now, this is a standard used every day in every criminal courtroom across the country. All it means is that you must be as sure of his guilt as you would be before you chose to make any important decision in your own life. With science, physical evidence, and the defendant's own words certainly prove that here. Now, with all of this evidence in mind, this defendant doesn't say, "I didn't do it." Instead, he asks, "Relieve me of any responsibility, because when I chose to get this, take it into Nathan's bedroom and strangle him, I was temporarily insane." The defense needs to prove this by clear and convincing evidence, a high degree of certainty that the defendant was suffering from a severe mental illness, that his illness was flaring up at the exact time of the killing, and that his illness prevented him from understanding that he was strangling his son or from understanding that it was wrong. They must prove all three of these claims. How do you know he's not schizophrenic? He never exhibited symptoms before he was arrested. He wasn't diagnosed with schizophrenia until over a year after the murder. His words and his actions from the night of his arrest show a man in control of his mind. And the only diagnosis this defendant received before he had a reason to fabricate was anxiety. Dr. LaGreca has no loyalty to either side in this case. The defendant is not a former patient of hers. She is not a fellow veteran. She is independent. And she has explained to you that the defendant was not experiencing hallucinations or delusions rather, but justified paranoia about his wife's affair. The defendant was not experiencing hallucinations, but anxious internal thoughts about his wife, his marriage, and his family. The defendant did not exhibit disorganized speech nor prolonged catatonic behavior, and any emotional troubles or negative symptoms could be explained by a high-stress military job and a problem marriage. Science explains by the moment the police caught him, he mentioned the CIA for the first time. Why moments after he was identified, he went from jumping jacks to catatonic zombie-like behavior in 5 seconds. Our expert diagnosed the defendant with malingering, and he has the symptoms that the DSM requires for this diagnosis. He is facing the most serious criminal charge of first-degree murder. His symptoms after the murder don't match up with his medical history, and he was uncooperative, combative even, during his evaluation with his own defense psychiatrist. Our expert proved the defendant is malingering, and their doctor agrees. She couldn't rule out malingering. Ultimately, an expert's opinion is only as good as the facts of the case. Our expert analyzed the facts before and after the murder, and they all support her conclusion that he was malingering. Schizophrenia wasn't observed in his childhood. Schizophrenia didn't impede his ability to graduate with honors with a degree in computer science. Schizophrenia didn't appear in his military hospital when he was observed for 72 hours, and schizophrenia didn't prevent him from holding a steady job at Computerland for 8 years, where he was described as a fantastic employee and where he was seen just 1 day before the murder and seemed completely fine. This defendant wasn't experiencing schizophrenia after the murder either. He tried to cover it up, and people only do that when they know they've done something wrong. He signed an initial to Miranda waiver saying that he understood and knew what he was doing in 5 places with the smoothest penmanship you've ever seen. Furthermore, during police questioning, he was coherent, He responded to questions, his answers made sense, and he made eye contact. The defense burden was to prove to you that it is highly and substantially more likely than not that this defendant was insane, that his illness prevented him from understanding the nature or quality of his actions. He may have anxiety, he may be a little depressed. But the law reserves the insanity defense, the defense that says you have zero responsibility for your actions, for those that are way beyond anxious, way beyond depressed. Members of the jury, he's nowhere near there. When lawyers stand in front of you, they have to answer tough questions. Hold us to that standard, but hold the defense to it as well. There are questions they have to answer. How can they prove by clear and convincing evidence that this defendant didn't know what he was doing was wrong when he tried to cover up the murder? How can they prove that when their own doctor says, yeah, can't rule out malingering? And how can they prove that when the defendant tells us, I messed up? When these answers come, if they come at all, and they don't add up, tell them that. Explain to this defendant that he cannot avoid responsibility for his choices. Walking out of that room, picking up a belt, and slowly strangling 6-year-old Nathan Ray. Do that with the only proper verdict supported by the facts and by the law. Guilty of murder. Thank you.
Thank you, Ms. Maurer. Mr. Hitchcock, we'll just give maybe a few seconds, and I think that's enough time. So you may proceed with your closing argument when you're ready.
Yes, Your Honor. I missed the signs. Timothy Ray is in a waiting room. Again, same curtains, same clock, same problems. The voices, negative thoughts, the family issues, it's becoming unbearable. He knows something isn't right. It never has been. He just doesn't know what. So he hopes maybe this doctor will finally give me an answer. But an hour later, he leaves without one. Year after year, Timothy Ray would book another appointment, sit in another waiting room, and see another doctor. But year after year, he'd leave those appointments with no answers, no treatment, and no diagnosis. His problems didn't just go away, but they got worse. And eventually it was too late. Mr. Ray's schizophrenia took control. Nathan is gone because they missed the signs. Today, the state has charged Mr. Ray with murder, and normally the burden would be solely with them, but we aren't disputing what happened to Nathan today. Instead, today's case comes down to our affirmative defense of insanity. This defense exists because sometimes people do horrible things, but because of mental illness, they don't realize what they've done. So while the law says there must be consequences, those consequences aren't criminal. Now, with this defense, we have a burden, but it's not the burden that you might be familiar with. It's not beyond a reasonable doubt. Our burden is the much lower standard of clear and convincing evidence, simply meaning much more likely true than not. And to prove our insanity defense, we just had to show two things. One, that Mr. Ray had schizophrenia, and two, that schizophrenia caused Mr. Ray to lose control and harm Nathan. I'll take those one at a time. First, we've proven that Mr. Ray has schizophrenia. Dr. Riley, the only medical professional you heard from who ever evaluated Mr. Ray, gave sworn testimony she is confident he is suffering from schizophrenia. And we heard the reasoning behind this diagnosis. But while a diagnosis of schizophrenia is medically sound if someone exhibits just 2 symptoms for a month, Mr. Ray had been exhibiting 3 symptoms for years, some dating back to his childhood. He would have negative symptoms, strange and erratic behaviors, locking himself in a bathroom, changing his mood at the drop of a hat. He would have delusions, paranoia about his wife and his son, conspiracies about the doctor conspiring with them to hurt him and to leave him. And he would have hallucinations, seeing strange shapes in the world that weren't really there, and hearing voices telling him to do horrible, horrible things. The state wants you to believe that we haven't proven that this cause and effect on his interpersonal relationships, but you heard from Dr. Riley that Mr. Ray became a completely different person. His disease caused him and his wife to break up. If that's not interference, I don't know what is. Today, the state came before you and they brought you some Google searches. And they want you to believe that these show that Mr. Ray knew what he was doing when he killed his son. Except they don't, because these Google searches happened after Nathan died. Think about that for a moment. Why would Mr. Ray commit a heinous crime that he knew he'd be the obvious suspect for without thinking about how to get away with it beforehand if he wasn't insane? He wouldn't. All these show is that he realized what he had done after it was too late, after he was out of that schizophrenic break. Now, the prosecution wants you to believe that you can't trust Dr. Riley, that she's just some hired gun, but members of the jury, her investigation was thorough. Clinical interviews, the best practice in the field of psychiatry, something the state psychiatrist never did. She reviewed every piece of evidence in this case, and if that's not enough, she conducted 3 more interviews with people who know Mr. Ray intimately. His wife, detailing the years of antisocial behavior that led to their breakup. His boss, erratic moods at work, and his father, a family history of mental illness, all corroborating that Mr. Ray's symptoms before killing Nathan are real. That's how we know that the symptoms he showed after killing Nathan are those of schizophrenia. You heard from Officer Wentz about CIA accusations, about talking to himself, erratic head movements, and jumping jacks at a traffic stop. You heard from Detective Booth, again with CIA accusations, this time bringing up the conspiracy between his wife and his son, and voices. They told me to, without explanation. And again with Dr. Riley. Again, government agent accusations. Again, conspiracy. Again, voices. In that clinical interview, Dr. Riley finally saw the signs. That Mr. Ray's behavior isn't normal because Mr. Ray isn't normal. He's schizophrenic. And this brings me to my second point. That on the day that Nathan died, Mr. Ray's schizophrenia was so severe it caused him to lose sight of the difference between right and wrong. A minute ago, the prosecution came before you and reminded you of the gruesome and horrific details of October 17th, 2018. How a loving father suddenly did the unthinkable by using a belt and wrapping it around his son's neck and pulling all over spilled juice. Members of the jury, I bring that up because those details are shocking. They are horrific, but they're also evidence that Mr. Ray was insane. Because sane people don't kill their kids. Remember, there's no history of abuse, no desire to harm. No, instead, Mr. Ray was trapped in his own mind. Hallucinations, delusions, paranoia, it caused him to lose control. Today, the state made their case about malingering, claiming that Mr. Ray is faking his symptoms. Their expert who came to that conclusion, Dr. LaGreca, who opposing counsel referred to as independent, not loyal to anybody. You saw her twist and turn in the examination chair when my counsel was asking her about delusions. You saw she almost slipped. She said para, about to get to a paranoid episode, a symptom of schizophrenia. Why didn't she want you to say that? Because 7 out of 8 times she's testified for the state. Slip up and it won't be 8 out of 9. Let's talk about Dr. LaGreca's expert opinion. She concluded that Mr. Ray was malingering. She did all of this without ever meeting Mr. Ray, without ever talking to Mr. Ray, without ever being in the same room as Mr. Ray and seeing his behavior for herself. In fact, none of us get the chance to see Mr. Ray's behavior for ourselves. We could have. There was a recording, but we don't have it because the detective decided not to preserve it. He chose to let it get deleted. Well, why would he make that choice? If someone had just confessed to killing another person, wouldn't you want to keep that evidence? So ask yourselves, what was in that recording? No, really, what would it show? Was Mr. Ray screaming? Was he crying? Moving or shaking? Where was he looking? Did it appear like he was talking to someone who didn't exist? We'll never know. Well, why would the detective not want you to see this for yourself? Well, that's pretty clear. He told you on cross-examination, quote, "I let my emotions get the best of me." Fact is, the detective saw the signs. The detective knew Mr. Ray was insane, but because he thought Mr. Ray is a piece of shit who would be better off dead, that's right, a piece of shit who would be better off dead, he couldn't let you see the signs for yourself. Members of the jury, I want to make one thing clear. Despite what the prosecution implied, finding Mr. Ray not guilty by reason of insanity isn't some magical get-out-of-jail-free card. Instead, it just means making sure Mr. Ray receives the treatment he should have received long ago if doctors hadn't missed the signs. The convictions are for people who do wrong and mean it, guilty hands and a guilty heart. But Mr. Ray isn't evil. He's sick. While there may be blood on his hands, there isn't evil in his heart. Mental illness, it's not murder. This is the jury verdict form. In a few moments, you'll leave here and begin your deliberations in this case. And when you do, we ask that you choose to treat Mr. Ray for his disease, not punish him for being sick. We ask that you find him not guilty by reason of insanity. They missed the signs. You don't have to. Thank you.
Okay, thank you, Mr. Hitchcock. Ms. Maurer, if you'll just give us a couple seconds for our evaluators. I think that's enough time, and you are free to do your rebuttal.
The defense is asking you to believe the unbelievable. That a defendant who could waive his Miranda rights, sign his signature perfectly at 2 a.m., try and deceive the police, and do an internet search worthy of the most guilty conscience could do all of that, but was insane for the minutes it took to strangle his son. That doesn't add up. The defense is right. Our detective booth did not produce the video recording. Their defense didn't produce the defendant for evaluation to our expert in a case that is determined by his mental state. Dr. LaGreca, as I explained, performed a perfectly thorough evaluation with the resources she was given. Dr. LaGreca's evaluation was thorough. Their doctor couldn't even bother to address the second factor of the DSM diagnosis for schizophrenia. Yes, we do want you to rely partially on these internet searches about countries that don't extradite for murder and how to get rid of a body. But as the defense left you with a form to consider, I want to leave you with one as well. His Miranda waiver. Please read along with me. I understand what my rights are. I understand and I know what I am doing. None of that is clear and convincing because none of that makes sense. His choice was to kill. They don't dispute Nathan's death. They failed to prove he was insane. The only verdict that adds up to is the one his choice requires. Guilty. Thank you.
Thank you, Ms. Bauer. Okay, we're done. Y'all did fantastic. I'm pretty sure that Phil would like the jurors who have been evaluating this this trial to get your ballots in so that he can calculate that. I will say that it was very impressive. I was impressed with both teams. I thought y'all were really, really good. And it was a privilege for me to preside over this for you guys. You know, I hope it felt like it went smooth. So I think it did. I think you guys were able to showcase your advocacy, and I know these judges are going to have a hard decision. I guess, Phil, if you want to let me know, I guess you're just going to wait on the ballots and then we'll come in.
Yep. As soon as the ballots are in and we have all of them, we'll tabulate them and we will get you guys results as soon as I can.
Okay, I do have it in the chat there from one of our jurors. You might need to address it.
Yep, I see that, and I will get her a ballot momentarily.
Perfect. All right, so let's just wait. You guys just be ready and available. I'm sure that when the ballots come in, I'm assuming that you'll get the announcement as we're all sitting here. So just relax for a second and try not to be too nervous. I'm sure it's nerve-wracking, but you guys, I mean, the work that you put in really showed. So I'm really proud of all y'all, and it was awesome. So great job.
And I just put our ballot, a link to our ballot in the chat. And so I think our one juror doesn't have a ballot. The link to the ballot is in the chat. So if you just click that link, you should be able to fill your ballot out. And Jason, you guys can start comments while we're waiting on just our last judge to, well, actually, take it back. My tournament director senses are still kicking in, even though we're late in the tournament. Why don't we actually hold off on that while our juror is filling our ballot out?
Okay.
Okay, we have all ballots, and once our judges, our esteemed panel, are finished with their feedback for our competitors, I will give you guys your results.
Perfect. I'd like to just start off. Just, you guys, y'all have already heard how I feel about y'all. I think y'all did a great job, and I know that you're proud of yourselves. I know your coaches are proud of y'all. And they should be. If I were your coach, I'd be proud of you. So I do want to say some general things about the tournament, and this is for the jurors as well. We really appreciate you guys coming and doing this and evaluating, because without y'all, all this work they put in, it'd be really to no point and no purpose. I want to say that Phil has run a fantastic tournament. I know he's a credit to Drexel. It's very difficult to do something like this. We're doing something where we are like this, and it is so hard. And this thing went off really, really well. I know Gwen and Abby are proud of Phil. And, this tournament is a one-of-a-kind tournament in this country, and we love coming every year. We're glad to and excited to come. It's one of our favorites because you guys get to deal with actual experts, and then the experts get to deal with you. These are all doctors that are going to eventually have to be cross-examined by lawyers, and so just the benefit of that experience that goes both ways is truly fantastic. So with that, I just want to say that I'm glad you guys got this opportunity. I hope that when you guys are out of law school and you come back, that you go to your respective schools and you help out. I do not know what the results are, and if I had a ballot, there would be no way that I could pick which one of y'all. Y'all were both so good, and the level was so high. So I think Phil was right. It was extremely high level. So with that, I have some names on the screen, and I'm just going to go by the names. So I guess I'll start with Juror McMonigal. Do you have any comments that you'd like to talk about with the team?
Well, Your Honor, just to say, I'm in awe of what I saw today. You guys were asked to perform under some very difficult circumstances, and we all recognize that. In the years to come, you will find yourself, perhaps not like this, but under difficult circumstances. And I only hope that you will honor your profession like you've honored us today. I couldn't help but just be struck by the amount of preparation, thought, and talent, obviously. And to your coaches, to your families, to all of you, just magnificent. Trying to pick between these two teams is an impossible task, and yet we do so. But you all won today, and I want to thank you all for giving me the privilege of watching you. Well done.
Thank you. Couldn't agree more. Let's hear from Juror Dandy.
Hi, everyone. Thank you so much for the opportunity to be able to watch you guys. You are so talented. And I would also echo that you guys are doing this under difficult circumstances. And I commend you not only for your trial presentation, your trial skills, your knowledge, but also for the ability to be able to adapt to the current times. As a trial lawyer who likes to use the courtroom, I like to use the space, I like to use the different areas to be able to speak to the jury. For me, the idea of doing something over Zoom, specifically a trial, would be very difficult to understand and comprehend and wrap my brain around. You guys did it in a way, though, that made it very, I don't want to say entertaining, but it was pretty entertaining. And it was good to watch. I enjoyed every moment of it because it felt like you guys were bringing me into the courtroom, even though we're doing this via Zoom. So I just want to thank you for that. You guys are all talented. I'm excited to see where your careers are going to go. I agree that it was very difficult to pick between you two teams because you both did such an excellent job. So I just want to commend you and also thank you for the opportunity.
Thank you. Juror Curian. I think you're on mute. We can't hear. I think what he's trying to say is y'all are awesome. All right, well, see if we can get your sound fixed and we'll go to Juror Bradford.
How you doing? Can you hear me?
Yes, we can hear.
Good. So I'm not going to repeat everything that Mr. McMonagle and Ms. Dandy said because I definitely echo those things. Let me tell you though, this type of case where you're using experts, even in mock trial, it's really difficult because experts are one of those things that many lawyers dance around because those expertise are owned by those individuals who take a deep dive in that study in that field. And the way you guys navigate it, an area of expertise that is not your own, an area of expertise that you're not learning in law school, and really ask the poignant questions, cross-examine in the exact areas that a jury would really pick up and perk up and start to understand this a lot better in terms of how it advanced each of your theories of the case. I thought was perfect. There was a few things, if I can go through some notes that I took, that I thought was absolutely amazing. Let me tell you, I thought the cross-examination of the first detective was stellar. You know what? The way you went through each and every point of bias that officer had in terms of what he did not do, in terms of some of the things that he said, and then delineating all of those factors. When he said that the guy was fine and he understood, I thought that was a great pushback on that discussion, because if he's saying that the guy seemed pretty well and the ultimate issue was he understanding, the fact that you pushed back on that with that objection was good. I thought the prosecution did a great job also with coming back and answering why those objections were not valid. But I mean, that cross-examination for me, and I should say I'm a defense attorney, so this is coming from some of this vein. I just thought it was very well executed. Prosecutor, I also thought that the cross-examination of the doctor was really, really good, meaning of the defense witness's doctor. I thought that the way you showed or exposed certain things that I took for granted during direct was it was really an eye-opening and kept this trial very balanced. I hate being a juror because I am not a good juror. I'm a flip-flopper. Oh, that was a good point. That was a good point. This one would be really, really tough for me in trying to figure out where I would go. So I'm glad this is not real. I'm glad I don't have to make this decision. You both did a phenomenal job, and thank you so much for all of your effort. I too cannot wait to see you in the field in the future, and I know we're going to be in good hands with such great advocates as yourself. So thank you so much.
Totally agree. Those are great comments, and I agree with all those. Juror Curian, have you been able to figure out your sound or? Ah, perfect. So if y'all look to your comments, he is, our other juror is giving you some of the feedback. And it's kind of funny, we've all pointed out, it's with all the technical issues and everything else, and this is really difficult to do in your bedrooms and in your living rooms and wherever you guys are. But yeah, you guys are fantastic. So with that, I guess I'll turn it over to Phil, who has what you're waiting for anyway. If Phil's here.
I'm very much here, Jason. Very, very much here. All right, so we'll get to it. First, thank you to our just incredible scoring panel. And of course, to Jason Goss, who is a trial lawyer in Texas and one of the fantastic coaches at St. Mary's Law School in San Antonio. We had some logistical issues with finding a presiding judge for our final round. And I called Jason about an hour and a half before the round to step in last minute. And not only did he say yes, but he was super excited about it. And he did a great job presiding over this round. So thank you, Jason. We started with 16 of the top trial advocacy programs on Friday morning, just 3 days ago. And we got down to 2. This was a fantastic final round. I think our best final round yet. And I can't say I'm surprised. I don't know these students, but I know their coaches and I know their schools, and they're excellent. Needless to say, Roger Goodell, he can't be happy right now. Congratulations to both teams. Representing the state of West Carolina was Temple. They were undefeated going into this championship round. They only lost 1 ballot in the entire tournament going into this round. And they are the reigning Texas Young Lawyers Association regional champions, as I'm sure many of our scoring judges on this call right now know. And they're excellent. Representing the defense was UCLA. They are the defending Summit Cup champions as of just a couple of weeks ago. And they are #1 in Fordham's trial competition performance rankings for the 2019-2020 season. This truly was a clash of the Titans. So I won't belabor the point anymore. Your 2020 Battle of the Experts champions are UCLA. Congratulations to both teams. Thank you to our scoring judges. Thank you to Jason, and thank you to everyone that's watching and who's watched throughout the weekend. We really appreciate it. And we'll see everyone next year.
Congratulations, guys.
Great job, too.
Amazing round. Thank you guys so much for that. That was so much fun.
It was fun playing with you guys.
Yeah.
Thank you, guys.